Yes, Mr. Chaudhary?
My Lordship's indulgence, I seek to mention item 33. My counsel has taken a leave of absence. I have to engage fresh counsel in this matter, my lord. And
Item 33.
Item 33, my lord. And in the IA which she had filed, I find, my lord, that there's a similar question raised in another writ petition.
All right, you want some time.
I want some time and I want it linked up with another case. my lord.
Okay, very well.
The other case is RERA appeal number
Just
3.
1 second.
My lord.
Since Mr. S. Sharma is on leave,
Miss.
Mr. MS. S.
Miss.
Sharma is on leave. Mr. Prashant and Chaudhary, petitioner in person, is present in court personally. He seeks a short accommodation in the matter. Prayer is allowed. Relist on such and such date along with such and such. Kamal, all right. On 19th of March or February. Yes.
Obliged, my lord.
Just give that slip to
I'm
the
good,
peer.
I'm-
Yeah.
May I
Next.
please, my lord, I am for item number 47. This matter should be listed on admission column under order 41, my lord. But wrongly it has been listed, so it may be.
47.
Yes, my lord.
Substantial question of law needs to be framed. I think some service, we will pass an order. You wait, it's in the order. Don't make a mention of the order. Let us see why it has been placed for order. Perhaps for recording of completion of service. We will see when the matter is
But I
called.
have not been admitted yet, my lord.
I know, but the matter is listed for orders, right? It is for some specific reason. Let us see when the matter is called. Yes. Any more mention?
Maybe there's a Lordship. Lordship, I'd like to mention item number 26, my lord. My senior is now out of station, my lord.
20?
26.
26 again is an order matter.
My lord, this is the, my lord,
You
question
wait.
matter.
You wait. Order matters. Just wait for your turn. This court is not going to pass any prejudicial orders. We will see when the matter is called. Why it has been placed before order. It may be for recording completion of service, etc. Let us see when the matter is called. You wait.
Yes.
Yes.
Okay.
May it please your lordship, I beg to mention admission item 5. As senior counsel, Mr. S. Dr. counsel station also. You have taken consent of the respondent also.
You have not taken.
Taken.
You have taken. So you are for petitioner,
Petitioner.
appellant, right?
Appellant.
Or petitioner. This is CRP.
Yes.
As prayed for by MS S. Musahari, learned counsel appearing for the petitioner with consent from the other side, relist on, yes. When do you want it?
Next week.
Date.
Okay.
Yes.
First is item number 6 of today's list, madam.
Yes.
Other side has not appeared also. It may be taken up next week.
All right. As prayed for by Mr.
H. Rahman.
H. Rahman, learned counsel for the petitioner, relist on such and such date. एक मिनट. Yes, agreeable.
Lordship, I am for the insurance company, Lordship. If
Where's the other side?
payment side, Lordship, their name has been shown the cause. This was not coming. Lordship may refer to for a timing, Lordship may admit this appeal and may refer to Lordship may yes.
But if the other side is not agreeable, we need to refer only if both parties are ready.
Then Lordship may kindly.
So why don't you inform them?
So for this, their name has been shown, Lordship.
The names are shown.
Yes.
So we'll have it. Can we call it after some time? Or at 2 o'clock?
I have to
Huh?
take the phone number. I'm not aware of this.
Inform them. Otherwise, we will have it relisted. Okay, we get it relisted. Heard Mr. J. Kalita, learned counsel appearing for the appellant. You don't have any objection, huh?
No, Lordship.
He submits that he has no objection if the matter is placed before the mediation center. However, there is no appearance on behalf of the respondent on call. Released on such and such date. Let registry intimate the learned counsels appearing for the respondents as regards the next date fixed in the matter, so as to enable whether they are agreed agreeable or not for referring the incident matter to the mediation center?
Lordship. 27, Lordship. Obliged.
Items 2.
May please be my lord. But if, actually, this appeal has not been admitted yet. So
Not yet admitted.
they should be admitted, and I'll take steps, and then LCR may kindly be called for.
Heard Mr.
A.R. Agarwal.
A.R. Agarwala, Learned Counsel, appearing for the appellant. You are also appearing?
Yes.
Also heard MS. A.
Biani.
Biani, Learned Counsel, appearing for respondent number one. One.
Her name may kindly be shown.
We may be allowed to file a fresh wakalatnama as well.
Okay. By way of this appeal under so-and-so of the MACT Act, so-and-so, the appellant is assailing the is seeking modification and enhancement
Enhancement, Lord.
of the amount of compensation awarded by the learned member, Motor Accident Claims Tribunal number 2, Kamrup M, Gauhati, in MAC case number 1849 of 27.
Place people number 1, Lord.
Huh?
1.
White judgment and awarded at 6/7/2021. Why have you written 2 here in your prayer? Why are you all not careful when you all draft the petitions? See page 10. What is there? MACT Tribunal number 1 or 2 is there?
Sorry, Lord, you will get it right.
What is there? Please read it out loud.
2, Lord.
Why? Why 2 is there?
Lord, in the
So
topmost
if
page.
you don't correct it, then obviously a wrong reference will go in the order.
In the first page, Lord, it
Yep.
is
What does that mean, Mr. Counsel? That you will give the right information in the first page and a wrong number in the prayer portion?
The typographical mistake.
So you must be more
Yes,
careful.
Lordship. Sorry, Lordship.
Make that correction.
Yes, Lordship.
1 Corredia, huh? Admit so-and-so accepts notice for 1 and registered post AD for 2 and 3. You file your power. You don't need the direction from this court. Call for TCR, relist on such and such date after 4 weeks.
Item 3.
Yes.
Not here. Has to be admitted, then it will be sent to the university. Yeah, admit this and it's in quantum basically, and so 50% I am willing to deposit. After the party, then we can go for it.
Heard Mr. R. Goswami, Learned Counsel, appearing for the petitioner. This appeal is preferred under Section 173 of the MV Act 1988, assailing the judgment and award dated 4/3/2025, passed by the learned additional member number 1, MACT Margareta Tinsukia, in MAC case number 5 of 2020, filed under Section 166 of the MV Act. On the ground inter alia that while making an assessment of the loss of dependency of the learned additional member, erred in not making any deduction for personal expenses of the deceased. Grounds appears to be arguable. Admit, notice, call for TCR, relist on such and such date.
For stay also.
Hmm?
I'm willing to deposit 50% against the stay order.
You have already?
No, I'm willing to deposit.
You are willing to, subject to deposit of 50% of the awarded amount, the judgment and or award dated so and so shall remain suspended. And on an application made before the registry upon verification shall release the same to the claimant.
Obliged.
6th amendment. Item 4.
The appellate settlement of he is coming, I inform him
All right.
after some time.
Okay. You are informing the appellant.
Prohibition item number 7.
Yes, Ms. Mushari.
Lordship, on last occasion, it was upon respondent to inform the court whether any appeal has been filed or not.
But where is your counterpart today? Where is Dr. B.N. Gogoi? He's not here. Wait for some time.
Yes, Lord. Okay. Lordship, I'm appearing on behalf of my senior.
Dr. B.N. Gogoi?
Yes.
Yes.
He is in another court. Kindly pass over for the family. Okay.
Item 8.
Yes. What is the order that is under challenge?
My lord, let me read it. So far the order that is 21/11/23, whereby the learned court below has directed the Latmandal to demarcate the land, and subsequently by the order dated 6/12/2023, whereby the commissioner's report has been, my lord, accepted by the learned court below, without appointing the advocate commissioner, and that too, my lord, the advocate commissioner has done some act which has not been, my lord, empowered to him to done.
No, your ground is that the advocates commissioner has not been appointed
Appointed in the school,
in the suit.
and he has submitted a report, and thereby, my lord, he has
Who has submitted a report?
advocate commissioner,
But you said he was not appointed.
not appointed, my lord.
Then
What happened, my lord? Along with the
where is that order?
my lord, page, my lord, 76, my lord. I have also included the entire order sheet, my lord. Nowhere he was appointed.
76 is the impugned order.
In order, my lord. 21/11/2020.
21.
11/2023.
What is wrong? This is not a final order.
My lord, may I submit?
This is what you have filed a civil revision 115.
My lord.
But this-
May I submit? May I submit?
Sir,
May I submit?
yes.
What happened? Yes, my lord. If you lordship take note of the entire order sheet, page 40, my lord.
1 second. Before that, 76 is one order. And which is the other order? 612.
6/12 is
23.
page 78.
What by that order, what has happened? I'm just trying to understand the facts.
Yes.
Mr. Sharma, right? You are Mr. Sharma, isn't it? Mr. Sharma, by order dated 21 November 2023, the the circle officer was directed to appoint one Lat Mondal for demarcation of the subject land, right? That was the order.
Right.
Then that order was followed by the order dated 6/12/2023, correct? Now read 6/12/2023 order.
Yes, sir. Advocate Commissioner Mr. So-and-so has filed the commissioner report relating to demarcation of land measuring 2 kathas covered by diagram number so-and-so to kata number so-and-so. And in report, it has been stated that on 3/12/2023 at about 11 a.m., Advocate Commissioner went to the street land situated at Tangla Town, Ward number 2, under Dakua Moja, Horisinga Revenue in the district of Udalguri, and in presence of learned counsels of both the parties and also Amantapura from Udalguri Court and Latmandal of Horisinga Revenue Circle, along with some people also accompanied the present in the suit land. Advocate Commissioner report reflects that he saw a steel set at the front side of the suit land, covering about 5 feet of the petitioner's land. So, but thereafter, immediately the pin facing was removed permanently. Thereafter, with the help of Latmandal, 2 kathas of land was measured, covered by diagram number so-and-so, of periodic patta number so-and-so, and has found 80 feet into 70 feet, which is 2 kathas of land, and handed over to the plaintiff. And after that, both the parties have mutually agreed that the defendant number so-and-so shall hand over 12 feet into 20 feet plot of land in the left side of the land for the purpose of entrance route to the plaintiff's plot of land. And in return, the plaintiff has handed over 70 feet into 2.5 feet of land adjacent to the backside of the defendant's plot of land. It has been agreed to by with the parties concerned. Consequently, the last pillars were installed at the boundary in presence of witnesses, neighbors, some localities.
So the defendant agreed to hand over left side of the land for the purpose of entrance, and the plaintiff
That
agreed.
was the report.
That was the report.
That was.
That was to hand over the backside of the defendant's land, right?
Now,
This was the arrangement.
The-
Now, this according to you is not correct.
because of the fact, the lordship may take note of or page 93.
Page
93.
93.
9. What happened, my lord? Along with the miss case, my lord, the present respondent has filed a petition under order 39 Rule 1 and 2. In that case, my lord, the ad interim injunction was granted, and when the matter has been come up for final hearing, the respondent has made an allegation that the ad interim injunction was violated. Basing on such, my lord, submission made by the respondent's counsel, my lord, the learned court below has, my lord, appointed one commissioner, advocate commissioner, with a specific direction, which is at page.
Anyway, this case perhaps will need a proper hearing.
Yes,
This is so I'll admit it and put it for hearing.
My lord, if admission by suit has been stayed, my lord.
No, it's okay.
But
This
otherwise,
matter is not
law is very much settled, my lord.
very well. This matter will require some hearing. I'm putting it for hearing
my lord.
on a hearing date. I'll admit it. It's come up for admission today.
Admission.
Heard Mr.
And Kishan.
M.K. Sharma, learned counsel appearing for the petitioner. Also heard Mr.
That's so.
S. Sharma, learned counsel, Sahu, right? Sahu, learned counsel appearing for the respondent. The matter requires full-fledged hearing. Admit no formal notice as parties are represented. March 1st, big date. Released on such and such date for final hearing.
Or the interim order may be continued.
Interim, if any, shall continue till the next date of list.
Earlier.
May I please.
Transfer.
Lordship. And in this case, Lordship, the petitioner is residing at the West Bengal Coachbihar Lordship, and the respondent is residing at the Bongaigaon district Lordship.
Respondent is in
Bongaigaon.
Bongaigaon.
Assam.
And petitioner is
From West Bengal Coachbihar.
West Bengal.
Now, Lordship, the respondent has filed a divorce petition at Bongaigaon Court, Lordship. And subsequently, it is
Jurisdictional court must be Bongaigaon.
Lordship. But it is
Respondent is the wife,
respondent is the husband, Lordship.
is the husband.
Husband.
Marriage took place in Bongaigaon.
But so, my lord, and the petitioner is appearing from the West Bengal to Bongaigaon, Lordship, and that is why, Lordship, and for his safe journey, Lordship, and it is about 140 kilometers from Coachbihar to Bongaigaon, and that is why, Lordship, and he want to transfer from Bongaigaon to Dhubri. It is little distance, Lordship, and then it will be convenient.
Little distance.
Little is Coachbihar to Dhubri, Lordship.
You want this
Safe
to be transferred to Dhubri.
Lordship. And that because, Lordship, another one maintenance case is pending in Dhubri Court, Lordship, and he is receiving the maintenance from the husband, respondent, Lordship.
Any objection?
So, Lordship, we have filed our objection because the court at Dhubri would be quorum non-juris. The wife is not residing at Dhubri. The marriage was also has not taken place in Dhubri. Neither of
That's
the
all
parties-
right, but this is because of transfer.
Lordship, section 24 clearly spells out that a matter may be transferred from one court to another court, which has jurisdiction to try
24 of
CPC. Supreme Court can do it under section 25 of CPC because 25 is distinct from 24.
section 24.
24.
Let us see.
Yes, yes. General power of transfer and withdrawal.
Is what is wrong, it can be done.
Lordship, primary.
Transfer any suit, appeal, or any other proceeding pending before it for trial or disposal to any court subordinate to it and competent to try or dispose of the same.
Yes,
The
this
Dhubri court is competent.
this is as regards pending before it, before the High Court. Will
No, before the High Court or the district court. On the
let us read.
application of the any of the parties and after notice to the parties and after hearing such of them as desired to be heard or of its own motion without such notice, the High Court or the District Court may at any stage
Lordship.
on an application, if the parties are making an application, withdraw any suit, appeal, so and so, try or dispose.
To any court
And-
subordinate to it and
Yes.
competent to.
Yes, so Dhubri
Lordship.
Court is competent.
Lordship, now coming to section 18 of the Hindu Marriage Act, Your Lordship, regarding the competence.
You have any authority on this?
Lordship,
Otherwise, I'm allowing it.
Lordship, just the provisions first, then I'll rely on some authorities as well.
Give me AI 2002 Supreme Court 396.
What is clear?
Immediately I know. AI 2002 Supreme Court 2396. Yes,
Now, section 19 of the Hindu Marriage Act, Your Lordship.
Hindu Marriage Act Khandiba. Yes,
So, a petition for divorce, every petition under this act shall be presented to the district court within the local limits of whose ordinary civil jurisdiction the marriage was solemnized. Here, in our case, the marriage was solemnized in Bangladesh.
that's all right. That is the general
The
jurisdiction.
respondent at the time of presentation of the petition
Very
resides.
well.
The respondent here does not reside in Dhubri.
That's
Admitted.
understood. That is why the order requires to be given under 24 now.
That's what-
Otherwise, it could have been filed there.
That's what, Your Lordship. Perhaps, if I may submit in a slow manner, Your Lordship. 24 says, any suit can be transferred on an application to any court which has competence to try the suit. My submission is section 19 has got 3 points, Your Lordship. The marriage has to be at the place, it has to be filed at the place of marriage, at the place of residence of the respondent, or where the respondent is a wife, at the place where she resides. Now the wife resides in West Bengal, not in Dhubri. The marriage also was not
So in
solemnized.
matrimonial suit, the convenience of wife is not required to
It
be
is required to
taken
be
note
taken-
of.
It is required to be taken in convenience. For that, it had to be transferred to West Bengal itself. Because this court of
You
Dhubri-
don't have any problem, it is transferred to West Bengal.
No, Lordship, because this court of Dhubri will be a quorum non judice, Lordship. Because as per section 19 of the Hindu Marriage Act, it has to be either at the place where the marriage was solemnized, the respondent at the time of presentation of the petition resided, the parties last resided together, they have never resided in Dhubri.
No, West Bengal, how does it fall under 19? Because the
She resides.
respondent at the time of the presentation of the petition resides. So do you have a problem if the matter is transferred to West Bengal?
No, no problem.
So I'll transfer it to West Bengal then.
For that 25 petition before the Supreme Court.
Otherwise, Lordship, the
Otherwise, if both the parties transfers, I have filed my response as well, Your Lordship. The objection is filed
even then, Lordship, and the petitioner
for the convenience.
under 310 by the respondent, that is why I only want, I have annexed the another CR case, Lordship, that is already been stated by the Honorable Court, Lordship.
Sorry.
Under the another CR case is filed by the respondent, Lordship, against the present petitioner, Lordship. And subsequently, Lordship, the
Where are the grounds?
Lordship, and there is the threatening, Lordship, and the para number 3, Lordship. I have
Para
very
number-
clearly mentioned 3 of my petition, Lordship. And very clearly mentioned about 140 kilometer distance, Lordship. And even then one CR case is pending, that is also stated by the Honorable High Court, Lordship, that because the respondent is threatening the petitioner to withdraw the petition and even then divorce petition and the
Decision to, yeah.
the
Decision to.
and all the times, Lordship, the respondent threatening the petitioner, Lordship, to compromise the divorce petition, even then, Lordship, and one maintenance case is also, Lordship. So there is the apprehension, Lordship, and the respondent number, Lordship, and he filed a CR case against the present petitioner, that is also stated by the Honorable High Court, Lordship.
So your only ground of objection is that the court in Dhubri is not competent to try this case because neither the resident resides nor did they last reside there, nor their marriage solemnized. So no basically cause of action for the divorce suit arises within the jurisdiction of the courts at Dhubri. This is the only
This is the
submission that you are giving.
Lordship,
How do you react to that submission?
there are numbers of cases, Lordship, and kindly come to page number 9, Lordship, of my petition. And I have just mentioned the cases, Lordship, and there are disposed of only convenience of the petitioner, Lordship, the wife. And that can be accepted, Lordship, and I have numbers.
No, what are these number of cases?
These are the in favor of the wife, Lordship.
Which wife?
For the respondent is the husband, Lordship.
No, these are related to this case.
Similar.
So where are these judgments?
I have no, Lordship, just mentioned.
You have not mentioned, and you've given a list of the judgments.
Lordship, and
Who is going to provide these judgments? Huh?
Lordship, I'll provide. Lordship,
Then?
but
You
others,
provide it
Lordship,
after the case is over. I was taking in the matter of a final disposal. When will you provide it? If this is the kind of assistance that we get from the bar, how do we dispose of cases?
But just where is
We are often criticized about pendency of cases and and low disposal rates. Heard, Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. So-and-so learned counsel appearing for the respondent. Mr. So-and-so, in support of the prayer for transfer sought in the transfer petition, urges that for the convenience of the respondent wife, the matter be transferred to the court of Dhubri, which is vehemently opposed by the learned counsel appearing for the petitioner or stroke respondent on the ground that neither any cause of action, that neither the marriage had solemnized at Dhubri nor the parties last resided there. He further submits that the respondent presently is also residing in the state of West Bengal, within the jurisdictional limit of West Bengal state. Though a list of cases in support of the prayer sought has been given in the body of the transfer petition, however, the copy of these case laws sought to be relied upon, unfortunately, is not available at the time of taking up the matter for final disposal. Relist on such and such dates. Non-dated are given.
I'll provide, sorry, Lordship, and I'll provide all this.
Yes, please call the next.
16 March.
Obliged, Lordship, obliged.
Added
এই decision to the digit 5 new table of fiddle হবে ঠিক আছে এটা না লাগে
Petition, Lordship. This is a transfer petition, Lordship, seeking transfer from Golaghat to Lordship, Tinsukia, Lordship.
Golaghat to Tinsukia.
Yes, Lordship.
Why?
The petitioner is the wife, Lordship. And though the petitioner, Lordship, earlier is residing with the husband at Golaghat, but due to the compel, she has to leave the house because there is a dispute regarding, Lordship. The husband.
So marriage took place at Golaghat.
That is true, Lordship. Marriage.
And they were last residing at Golaghat.
Yes, Lordship.
And at Tinsukia is her residence.
Yes,
So
the petitioner is now residing with her old parents, Lordship, and it will take, Lordship, 5-6 hours to travel to Golaghat to contest the case, Lordship. And
are you having that decision which says that the convenience of the wife in matrimonial matters should be taken into account? Do you
Yes,
have it?
Lordship. I have this judgment of this honorable court, Lordship.
Mr. Ganguly, you're opposing it? Seriously opposing?
Yes.
Lordship, paragraph
If I submit one of them.
Yes, yes.
paragraph 7, Lordship.
Paragraph 7.
Lordship.
Yes, Mr. Nirola.
Yes, may I read, Lordship?
Yes, please.
Lordship, under what circumstance such a case can be transferred? It provides general and plenary power upon the High Court to make inter-district transfer of a case within the jurisdiction of the High Court. Normally, on such prayer of inter-district transfer, the court is to see to the balance of convenience between the parties, keeping in view of the basic principles of justice delivery system. It is further relevant for the court to consider the position of status of the respective parties in the society, taking note on the grounds taken in the transfer petition, and the resultant justice or injustice does not occasion on refusal or acceptance of such prayer. And then, Lordship, paragraph 9, Lordship. That's one of-
Yes.
one of the relevant, the consideration for passing an order transferring a matrimonial proceedings from one district to another district file against the wife is the wife.
It is the wife's convenience.
That should be looked into.
Yes, please continue reading it.
To be a question to be considered, what is the, that's what to consider such convenience. It is difficult to lay down with the straitjacket formula the necessary condition which constitute convenience. It will be vary from case to case. Admittedly, such convenience is required to be taken note of, so that is no injustice is caused to the parties seeking for such transfer, which is based on the ground principle of administration of justice, that is, parties should get proper opportunity to contest their case. On such principle, although under section 24 of CPC, the High Court is on its own motion can transfer a case. In normal circumstances, the High Court usually issued notice to the aggrieved parties. This is done for fair play in the administration of justice. On the above principles, a prayer made by the husband petitioner also may be considered in appropriate case, Your Worship.
All right. Yes. Now, what is your ground? Where have you stated?
Lord, my basic ground, Lordship, that the petitioner does not have any income source of her own.
She has difficulty in traveling to
Yes,
Golaghat.
Lordship, and the minor son, who is residing with the petitioner, and will take 5, 6, 7 hours to travel. And
How old is the son?
son is, Lordship, 6, 7 years, 7 years.
7 years is the, I think, marriage.
Son, Lordship,
Subject to correction, it looks like.
yes,
Because it
yes,
says
marriage, yes, Lordship.
marriage, I think, is 7 years.
Son is, Lordship.
So must be below that.
Minor son, yes, Lordship, minor. Son is minor.
Mr. Ganguly, you know the age of the son?
Manoj is about 6 years.
About 6 years old. Yes.
That is my ground, Lordship. It is difficult on the part of the petitioner to travel and to contest the case. And
she is currently residing with her parents.
yes, Makum, Lordship, Tinsukia.
What does the husband do?
Lordship, he is a government employee. So far, I subject to the correction, Lordship. He is a government employee, Lordship.
You're not doing anything. Yes, Mr. Ganguly.
First, Manoj, I would like to supplement the facts. Lordship will see that, Manoj, the petitioner has already appeared in the proceeding, which is now subject to challenge. Now, page 16, she has filed her written statement, which is already on record in the case that we have. So she has engaged an advocate. She has filed a WS. Along with the WS, Manoj, she has filed an application under section 24 of the Hindu Marriage Act. That, if your Lordship for a moment will have the Hindu Marriage Act, but that will, in my humble submission, will be very relevant. Because that will deal with the issue of financial
Yes, ma'am.
hardship.
Go ahead.
Section 24.
1 second, Mr. Ganguly. ঠিক আছে। And no, if some problem with the iPad, Bitika Kuba and Janet Matabula, they know the password. Section 24.
24. Maintenance, pendente, lighter, and expenses of proceeding. What should have it?
Yes, yes.
25 maybe. Wherein any proceeding under this act, it appears to the court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support and the necessary expenses of the proceeding. It may, on the application of the wife or the husband, order the respondent to pay to the petitioner the expenses of the proceeding and monthly during the proceeding such sum as having regard to the petitioner's own income and the income of the respondent. It may seem to the court to be reasonable,
So
provided
this
that the-
is expenses of the proceedings
Yes,
and all.
so that would include the traveling expenses also, and that application is now pending, my lord, before the learned court below.
Okay,
So now, my lord, she has admitted that she has filed the WS and this petition. So as
Okay.
far as the financial aspect is concerned, that is there, my lord, which there is no doubt that she is already participating in the proceeding. She has filed this petition, and the learned trial court now has to take a call, because this application, as per the proviso, is supposed to be disposed of within 60 days of filing. That is there. That is the first thing. Then, my lord, the important thing is that neither the court at Golaghat nor the court at Tinsukia are family courts. They are not family courts. They do not require, my lord, the personal presence of the parties. They do not have, my lord, the embargo of section 13 of the Family Court Act. Your lordship, for a minute, will have the Family Court Act.
Family Courts Act. But what is any difficulty for you to travel to Tinsukia?
Transfer, my lord, is an exception.
No, I'm asking, do you have any
Difficult,
difficulties?
because most of my witnesses will be from, my lord, Golaghat. The marriage, my lord, subsisted at Golaghat. We decided at
Have you
Golaghat.
filed an objection here? in
Yes,
this?
I filed, my lord.
So, what are the objections that you have taken? That
These are the objections.
most of the witnesses are from Golaghat.
Lordship, these are the, and my lord, ordinarily the transfer is a matter, you know, which is the out of exception. My lord. The earlier rule that the wife will stand up claim transfer, that, my lord, Supreme Court in 2006 said that leniency has to stop, and the convenience of both parties. Yes,
See,
privacy has
Mr.
to.
Ganguly, I am not on all that. Of
No.
course, we will weigh the convenience, we will
Right.
balance it. That is how I take these matters.
Right.
Now, when I'm trying to scale the balance, the one thing that is coming constantly in my mind is that she's living with her old parents and a minor child, and she's not doing any work. Now, of course, it's a family case matter. So her presence would be required. It's not a case where her presence at all will not be required. She will have to keep coming. Now, in that situation, if this court transfers it to Tinsukia, on the other hand, you are a government employee. You can always go. You can get it fixed in those days where you can.
For a minute, I should be considered. She will only have to go, and I will also only have to go on the date of evidence.
Right.
Only on the date of evidence. Now, this honorable court, my lords, coordinate bench of this court has already gone into the matter, examining the point from the aspect of section 13, and I would like to rely on these two orders of the coordinate bench. Because, my lord, section 13, if had it been a case of a transfer to the family court, then yes, the embargo would be there. The matter should have to be transferred.
Sorry. What is the first case?
First case, one I would like to rely on is the Supreme Court judgment, 2006 9SC 197.
Whose suit was this?
This was, my lord,
Husband's suit?
Husband's.
Yes, paragraph.
My lord's paragraph. It's a very short judgment, my lord. If I would just like to read out. This transfer petition has been filed by the wife on the ground that the petitioner has a small child of 6 years. She has further claimed that she has no source of income, and it is difficult for her, very identical circumstances, for her to attend the court at Delhi. She has further claimed that she is not claiming good health. In support of this petition, a large number of authorities have been cited, namely so and so. These authorities are all based on the facts of their respective cases. They do not lay down any particular law which operates as a precedent. Even otherwise, it must be seen that at one stage, this court was showing leniency to ladies. But since then, it has been found that a large number of transfer petitions are filed by women, taking advantage of the leniency shown by this court. On an average, at least 10 to 15 transfer petitions are on board of each court on each admission day. It is therefore clear that leniency of this court is being misused by the women. This court is now required to consider each petition on its merits. In this case, the ground taken by the wife is that she has a small child and that there is nobody to keep her child. The child in this case is 6 years old and there are grandparents available to look after the child. Respondent is willing to pay all expenses of travel and stay of the petitioner and her companion for every visit. When the petitioner is required to attend the court at Delhi, thus the ground that the petitioner has no source of income is adequately met. Except for stating that her health is not good, no particulars are given. On the ground that she is not able to come to Delhi to attend the court on a particular date, she can always apply for exemption and her application will undoubtedly be considered on its merit. Hence, no ground for transfer has been laid out. Accordingly, we dismiss the transfer petition. We have a direct that the respondent shall pay all travel and stay expenses of the petitioner and her companion for each and every occasion when she is required to attend the court at Delhi. The respondent shall send in advance to the petitioner money for a so and so, my lord. Respondent shall also pay stay expenses for a petitioner and her companion in a so and so. Trial court shall ensure the petitioner has been
Okay.
paid.
Yes.
Now, my lord, in accordance, my lord, considering the bar under section 13, this coordinate bench of this court, my lord,
Mhm.
has your lordship will have there are two judgments of the court.
Yes, Dipali Das?
Dipali Das, my lord.
Yes.
Now, your lordship will kindly come to Lord's para 9 on this.
You give the citations, Miss Nirula, it looks, you are taking her by surprise. If you don't give us the citations or the party's name, she will not know.
Not that I can hand over the copy, I just read.
Hand it over because how will she respond to all these arguments otherwise?
No, it's a
Miss
legal
Nirula,
document.
this is a Dipali Das Vaidya versus Partha Vaidya in TRPC of 65 of 2020.
The other judgment is also on by the coordinate bench, my lord, and on the same ground.
All right, paragraph.
My lord, paragraph, my lord, 10 onwards. Sagarika Paul, this one. If the bar was considered and the specific direction was made. by
Yes,
the
please
court-
read.
Yes, if I may read. It has been admitted at the bar that there is no family court established in terms with section 3 of the Family Court Act. In the district of Tezpur, and the divorce proceedings under the Hindu Marriage Act is taken up by the court of the district judge, Sonitpur at Tezpur. Under such circumstances, it has been submitted that the embargo under section 13 of the Family Court Act, which stipulates the mandatory necessity of the appearance of the parties before the family court, is not applicable to the matrimonial proceedings before the learned district judge, Sonitpur at Tezpur. In the backdrop of the said submission, this court therefore needs to take into consideration as to what inconvenience would be caused to the parties if the matrimonial proceedings are allowed to be continued before the court of the learned district judge, Sonitpur at Tezpur. As the embargo which is being imposed under section 13 of the Family Courts Act is not applicable before the court of the learned district judge at Sonitpur at Tezpur, the petitioner can very well participate in the said proceedings through a legal practitioner. It is not required for her to appear on each and every date, save and except when directed by the court wherein the divorce proceedings are pending. Taking into consideration that the CPC is applicable and is
So para 11 takes care of that application that is pending according
Lodge.
to you. Here,
Lodge.
in this case, she's already filed an
She
application
has
for the
already filed an
expenses.
In fact, my lord,
So here, in this case, in para 11, there was already a direction.
yes, and I'm sorry, which
But up
which-
for paying 3,000, the
Yes.
respondent shall deposit an amount of 3,000 before the court of the district
yes,
judge. Or
this court, my lord, directed the husband to pay in advance before the court,
yes.
while her petition is already pending, and she
So that's
has-
why I'm saying. So,
Lodge. So we are
but however, if in addition to whatever order is going to pass in that, if we
Lodge.
say ki till that is decided,
the
we
learned
fix.
court below will consider your lordship's order for expenses and adjust it accordingly, my lord, because there cannot be two, perhaps.
No, I'm just asking in
No.
case we think we go by because from whatever you have submitted, it appears that in a situation where the matter is before the district court
Right.
and not in the family court, since the matter can be proceeded by engaging a legal practitioner, the presence of the parties at all stages is not required. Only particularly maybe for the evidence stage is required. So that takes care of the
Yes.
inconvenience of traveling all the time the
Right.
matter is fixed.
Right.
Secondly, just because the wife resides somewhere else
Right.
automatically doesn't become a ground for transferring it before the court of her within the jurisdictional limit of her residence.
Right.
Isn't it? This is what you're submitting, and most almost all similar situation according to you was there before the apex court in that case,
Yes.
where the child was of 6 years. Though there was an argument that the child she stays alone with the child. However, it is noted that her parents are there,
That was from one state to another state.
another state.
Lodge.
But
And
here, of course, in that case, we don't know how old the parents are. Here, it has been specifically said
Lodge.
that the grandparents are old.
Yes.
You said there is a brother. From where you saying there is a
Yeah,
brother?
because that is admitted in the petition itself.
Your brother is there.
Brothers, no. Para 5.
Para 5 of the petition. And
Last but not my submission on the factual aspect is that she has already engaged. a
understood. I've already taken note of.
Nothing
Yes,
new
Ms.
to say.
Nerula, any other, and this the other one, Sagarika Paul is similar to
Sagarika Paul and Dipali Das are by the same bench, my lord, considering very similar.
similar. To which paragraph in
No, I think
Sagarika
in,
Paul?
The other one is para 9 onwards. Para 9.
Sagarika is 9 onwards.
I was there in both the matters. In one of them, I was in the receiving end, so I remember.
Okay. Which one were you in the receiving end? Let us see that.
I think, Balaz, I was in
Sagarika.
Sagarika also.
Ah, that's why you
No, I'm
chose
sorry,
to.
Balaz, not in-
Huh?
I was in Palida.
Okay. Anyway, Ms. Nirula, you
Yes.
heard the submissions. Yes, what do you have to say?
Lordship, regarding the family code, Lordship, it's the same goes to him also, Lordship. Again, he has only come for evidence only. If that petition
See,
is
if he has
transferred-
to come, he has to take leave and come.
Yes, Lordship, but
He's also he's working in the government,
Parents and relations will also have to come.
and the evidences, the witnesses, you see, are largely at Golaghat.
that is to Lordship, the witness, but Lordship, considering the situation this petitioner is facing right now, Lordship. Because
You have already engaged a lawyer.
Lordship, I have filed the written submission also, but the thing is, Lordship, the petitioner has filed another suit for the
Maintenance.
DV Act also, but that has been, Lordship, withdrawn because the petitioner could
No,
not.
that's all
appear.
right. But in as far as this present proceeding is concerned, you have not only engaged a counsel, you have filed your WS, and you have also filed an application seeking expenses, maintenance, and all that under Section 24 of the Family Court Act,
No, HMA.
of the Hindu Marriage Act. Correct?
Yes, Lordship.
So even that is under consideration.
That is,
And you don't have to come on every date. Whenever you come, you will be your expenses would be given. Your parents as well as your brother is there to take care of your 6-year-old son. He's not a 1 year. This court would have understood if it was a 1-year baby.
yes, Lordship.
Because in para 7 of my objection, I have made a specific statement.
All right.
That I undertake.
I'm
to
sorry,
take
Ms.
steps.
Nirula.
Lordship, then Lordship will give me one chance, Lordship. So
Yes,
that I
yes,
can-
I'm hearing you.
Yes, Lordship. Only the thing is, Lordship, the council said, Lordship, this you will pay the expenditure and all, Lordship. But physically the petitioner needs someone to accompany her to and to appear to the matter. And though she has filed this written submission, Lordship, if the proceeding goes on, Lordship, again she has to take a rented house and to stay there.
No, why she has to stay there?
Lordship, though petitioner could not appear every day, but only for the evidence, Lordship, only the same goes to him also, Lordship. He can also go for the evidence only.
No, I'm sorry. It's not appealing.
Again,
Your arguments are appealing to the heart of the court, not to the mind. Sorry.
Lordship, the same, Lordship, the Supreme Court judgment also, Honorable Supreme Court, considering the Lordship, here also the woman, the wife was working, and the Supreme Court has considering her convenient, the Supreme Court has transferred the.
You see, these are all matters of discretion, right? In some matters, it is given, in some it is not given. What is weighing in the mind of this court here is that you've already engaged a counsel. You have filed your written statement. You filed your application under Section 24, right? You don't have to go every day. The proceeding is not before the family court. It is before the district court. And you are not working, so you can go anytime. He's working. He's in the government. The witnesses are from Golaghat. So when we scale it, we find it is for the interest of justice, it would be appropriate that the proceedings continue at Golaghat. You may have to come once or twice only for your evidence, and those expenses would be given. You are going to be, it is not that you have to bear your own expenses and come. It will be taken care of. If required, we will put it in our order. But however, there is an application pending. That's why I thought I would just add that that application be considered ASAP. I thought maybe we put one line on that and dispose it off.
I think has not been taken because of the stay.
There's a stay order operating.
Yes.
So of course, once I dispose it off,
I mean, otherwise, in
everything-
para 7 of my objection, I have made the specific statement.
All right. Heard MSM Nirula, Learned Counsel appearing. M or N? M.
M.
Nirula, Learned Counsel appearing for the petitioner. Also heard Mr. A. Ganguly, Learned Counsel. A.K. Ganguly, na?
Aim.
A. Ganguly, Learned Counsel appearing for the respondent. By way of this application under Section 24 of the CPC, the applicant is seeking transfer of title suit M number 7 of 2025 pending in the court of the Learned Additional District Judge Golaghat to the court of competent jurisdiction in Tinsukia, primarily on the ground that since the petitioner wife is residing currently with her parents at Golaghat, at Tinsukia, along with her minor child, it is difficult for her to come to Tinsukia, to come to Golaghat to attend the court there. Stop. The brief facts of the case is that the petitioner and the respondent were married on 4/12/2017 as per the Hindu rites and rituals, and were living together as husband and wife at Golaghat. And out of their wedlock, a male child was born on 14/2/2020. However, after about 7 years of their conjugal life, due to dispute arising between them, the petitioner wife left her matrimonial home and went to live with her parents at Tinsukia. Accordingly, a suit for divorce was filed by the husband stroke respondent at Golaghat, being TSM case number 7 of 2025. MS Nirula so-and-so submits that since she is staying with her old ailing parents along with her minor son at Tinsukia and having no source of income of her own, despite she having her brothers, however, they being busy in their life are not in a position to help her, and therefore it is difficult for her to attend the court proceedings at Golaghat. She further submits that it is also difficult for the petitioner wife to travel to Golaghat on her own and participate in the court proceedings. Per contra, Mr. Ganguly submits that, just one second. What are the case laws you had? Just give me that list. In support of the above, she submits the following case laws.
2006 2 GLR 135.
लिखी लो. Just give that list. So and so. 2 cases, na, Ms. Nirula? 2 cases. Just my naam Twitter लिखिला पिसर दे दिबा. So and so. Per contra, Mr. Ganguly submits that the petitioner wife has already engaged a lawyer to represent her in the divorce suit at Golaghat and has also filed her written statement. He further submits that since the proceedings are being taken in the district court and not in the family court, her presence on each date is not necessitated. He further submits that the petitioner has also filed an application under Section 24 of the Hindu Marriage Act for pending and expenses of the proceedings, which is pending disposal before the district court at Golaghat. He further submits that since the petitioner wife is currently residing with her grandparents and her brothers. There is no difficulty for her to leave her 6-year-old son with her parents and brothers while she travels, while in the event she has to come to Golaghat to give her evidence. In support of the aforesaid submissions, he relies the following decisions. Number 1, 2006, Volume 9, SSC 197. Number 2, Dipali Das Vaidya. Number 3, Sagarika Paul. Egita amar coordinate bench. Egita might want leading me. I have given, Ms. Nirula, please take your seat. I have given my due considerations to the arguments advanced by the learned counsels appearing for the contending parties and have perused the materials available on record. Undoubtedly, in matrimonial proceedings filed by the husband, the convenience of the wife has to be kept in mind. Notwithstanding the same, the convenience of the husband is also not to be given a complete go away. In Anandita Das Supra, the apex court has clearly held that in transfer of proceedings of matrimonial disputes, convenience of both parties is to be adjudicated on merit and not merely show leniency to ladies. Stop. Relevant paragraphs of the aforesaid judgment reads as under quote unquote para 3 and 4. In the present case, it appears that the petitioner wife is already participating in the divorce proceedings pending before the district court at Borpeta by engaging a counsel of her choice. Golaghat. She has also filed an application under Section 24 of the Hindu Marriage Act so-and-so seeking expenses. However, in view of the stay order granted by this court in the present transfer proceeding, the aforesaid application has not proceeded before the district court. It is also evident that she is residing with her grandparents and her brothers, with whom her minor son, aged about 6 years, is also residing. It is further noted that the respondent husband is a government. What is he doing? Is a government
Service with APDCL.
Is working with the APDCL, and the witnesses are all from Golaghat district. Stop. In the event the matter is transferred to Tinsukia, the witnesses being from Golaghat would cause inconvenience to the witnesses. That apart, since the proceeding is pending before the district court and not the family court, presence of the petitioner wife is not necessary on all dates. And also keeping in mind that she has already engaged a counsel of her choice and filed her written statement, this court at this stage does not find any merit in the petition. Accordingly, the petition stands dismissed, no cost. However, it is made clear that the district court shall forthwith dispose of the application filed by the petitioner wife under Section 24 of the so-and-so in accordance with law.
Conduct your lordship. Observe.
But that application you have filed,
Lordship may observe, we have no difficulty with that. We have already stated.
how much?
Reasonable.
Considering that the petitioner wife at the moment does not have any independent source of income except to ask her parents in the interest of justice, this court is of the opinion and accordingly directs that whenever the petitioner's appearance is required before the court of the district judge at Golaghat, the respondent shall deposit an amount of
3,000.
Lordship, it will be 5-6 hours. It will be.
how much? Tell me.
Lordship, 7,000.
5,000. 5,000 I think is good, is sufficient perhaps to Tinsukia to Golaghat, right?
Tinsukia to Golaghat.
Rest none of the section 24 is.
But in that situation, if suppose she has to stay back,
Yes, Lordship, and if
That should be indicated to the learned trial court, my lord. We will, of course,
Again,
that
this
the
way
learned trial
long
has the flexibility to-
5,000 before the court of the district judge Golaghat, and in the event the petitioner and the petitioner upon her appearance before the said court on the said date shall withdraw the said amount with permission of the court of the district judge at Jorhat. It is further clarified, considering the distance of the travel time that is required to that would be that will be required, the petitioner wife may have to stay back at Golaghat to attend the court proceeding. In that situation, the said fact shall be taken note of by the district court while disposing of the application, pending application under section 24 of the So-and-so Act. I think that is sufficient.
No, the interim order.
Interim order shall vacate it.
Obliged.
Look, Lordship is indicating, I think that's only when her presence is required before the learned.
Yes.
But Biplab,
Whenever she is present, then she will withdraw it.
yes, as required by the learned.
I have not said if she has to come, she will come and you have to pay.
No, that is the other.
Anyway, I will see that.
No, that part, because the coordinate bench has passed. Biplab,
I think I have already dictated
I
that
think
part,
it
but I will have a look at
Sure.
it, okay? The decisions can I get up to it, you have, Pama? Anupamok did but yes.
Big item number 4.
Yes. No problem. Yes. This is first time. And I'm admitting it.
I am going to deposit 50%.
Okay. Any notice has to also go or everyone is here? Huh?
Appearing for respondent number 1 to 5 claimant,
You are appearing for 1 to 5.
but 5 has already expired.
Okay.
So,
So then appropriate, I think, application has to be filed for 5? No.
no need, because he was the father of the deceased. Now all are represented.
Okay.
So, and 50% amount that may be released in favor of the
We will
claimant.
file corrected.
What about 6, 7? You're for 6. Okay. Heard Mr. T.
T.
Kalita,
Kalita.
Learned Counsel appearing for the appellant. Also heard Mr.
M. Khan.
M. Khan, Learned Counsel appearing for respondent numbers 1 to 5 and Mr. A.R. Patgiri, Learned Counsel appearing for respondent numbers 6 and 7.
And that 1 to 4.
I will say that. Why do you all get so impatient? Yes, counsels, please don't have these interaction in the court. You can do all these interaction outside the courtroom. Take your seat now.
I'm sorry.
By way of these appeal under section 173 of the MV Act so, the appellant is assailing the judgment and order dated 30/11/2024 passed by the learned member Motor Accident Claims Tribunal Bongaigaon in MAC case number 144 of 2021. The appellant has made arguable points. Admit Mr. So-and-so accepts notice on behalf of respondent number 1, 2, 3, 4. He, however, submits that during the currency of that after post filing or before filing, post filing of the appeal, respondent number 5 expired. Mr. So and so, learned counsel for the appellant, submits that necessary amendment to the cause title shall be carried out. And you put it before the registrar. The name of R5 stands struck off koridibo para sane etu na. And Padgiri for 6 and 7. Extra copies to be submitted, subject to 50% of the awarded amount being deposited before the registry. The judgment and order dated so and so shall remain suspended. Upon proper verification and application, the deposited amount be released to the claimants. Call for trial court records, relist on such and such date.
The accompanying IA is disposed of by law.
What is the IA for?
I for stay.
Yes, disposed of.
Much.
Etu yate di delay ho jabo, right? To dismiss going. I have called for trial court records. Anything more you want, Mr. Khan?
No, sir.
You are behaving as if you are the appellant. Huh? Yes.
Handling item number 7.
Also be, in this case, 21/4/2025, this honorable court has directed to take instructions whereby the continuation delay has been admitted by the trial court and appeal has not been filed. But accordingly, the trial court has ordered on 25/2025. I have procured the certificate copy, although I have not filed the written statement, whereby the applicant.
Then you file your written objection.
Yes, Lordship, I have to file. I have received.
You have sought time to filing,
Yes.
filing, isn't it? You file it, you put everything in your written objection.
No.
Huh?
I have procured the certificate copy.
No, you file it.
I will file.
Let him file. Heard MS Mosahari, learned counsel appearing for the petitioner. Also heard Mr. Dr. B.N. Gogoi, learned counsel for the respondent. Mr. Gogoi seeks a short accommodation to file the written objection in the matter. Prayer is allowed. Relist on such and such date. 3 weeks.
Diplomas.
Second part. Item 11.
May it please your lordship.
First time?
Yes, sir.
Yes.
Your lordship, the engaging counsel is out of town. Your lordship would like to adjourn the matter.
Okay. But as it is submitted by Mr.
A. Deb on behalf
A.
of
Deb,
the-
learned counsel appearing on behalf of the appellant, that the conducting counsel, Mr.
D. Rathi.
B.
D.
D. Rathi, is out of station. Relist on such and such date.
Your lordship, similar prayer on item number 13.
On 30?
Item number 13, similar prayer. 1-3.
Okay.
Obliged.
120.
Do it same.
Item 12.
Yes, Mr. De.
Lord, please. My lord, this is an appeal filed by IIT Gauhati, my lord, against a land acquisition which was done in the year
First
1991.
time it has come.
Yes, my lord. So, my lord, the impugned order is at page number 79. I am for the IIT, my lord.
You are for the IIT.
Yes, my lord. So, my lord, if
There's no problem in issuing notice.
Yes, sir.
other side has to be the opposite, party number 2 has to be there.
So I'm issuing notice. Heard Mr. A.V. De, learned counsel appearing for the
Yes.
appellant. Issue notice. MS, your name,
ED Varma, additional senior comment.
so and so accepts notice on behalf of
Respondent number 6.
6. Only 6, na?
Yes, sir.
And the rest by registered post AD, steps
post.
within 3 days.
My lord, now it has been made speed post, my lord.
Speed post, sorry. It has speed post korbo lage nahi.
Yes, my lord.
Okay. By speed post. And call for TCR. Relist after 3 weeks. Give a date.
And extra copy maybe.
Extra copy by total.
Obliged.
Obliged.
He will give you. I have put it.
6th of March. 6th of March.
Item 14.
Yes, Mr. Deka. RFA.
RFA, my lord. First, from dismissal, there are shoot, my lord. This statement of
First time?
first time.
First time. So I'll issue notice.
Yes. There is no claim, my lord. because
There is
of-
no. All right. Heard Mr. Dekan Senior Counsel assisted by Mr. Bhagavati and also heard Mr. B. Bhattacharya for respondent number 6 and 7. Issue notice and so and so except, sorry, K. KK or K? KK. For 6, na?
6 and 7.
6 and 7 extra copies provided or baki speed post. And call for TCR, list on such and such date.
We are in, it is government land. We are not pro forma respondents, we are respondents.
All right, next.
Item 15.
PS Dekan record, senior counsel.
May I please your lordships? This RSA is against the order dated lordship 26/5/25.
What about steps you have taken?
Lordship.
Await service.
Yeah, lordship, we have taken.
I know, but the service report says it's not complete.
Lordship, that is the
Await service, relist on such and such date.
lordship. There, I have a IA application, lordship. Tomorrow is fixed in the execution court, your lordship. They are pressing very hard, your lordship.
What can be done? Your service is not complete, Mr. Counsel.
Lordship.
Give a date after a week.
Huh?
You want dusty service?
Lordship, that's the service.
Permitted dusty service and relist, give Friday. Friday or next week,
Lordship.
Monday.
Tomorrow is fixed there in trial.
Can't be helped.
The-
You
the
take
sta-
service.
Status quo may be maintained, lordship.
Sorry.
Lordship,
Next.
already the Nazir has visited the.
Service report says it is awaited. I have no materials before this court. Yes. Sorry.
Friday, lordship.
Friday.
Lordship.
Item number 16 and 17.
It is submitted that the execution proceedings are fixed tomorrow. Considering that so and so allowed to be taken permitted by dusty mode, then fix it on Friday. Yes.
That we are appearing for 16, my lord. Where the claimant, my lord.
What about the other respondents?
Lordship, I am for the respondent insurance company, New Indian, both the items 16 and 17.
You are for
The insurance company.
respondent numbers?
Respondent number 1 in item number 16 and respondent number 5.
MS?
8 Rani.
1 and 16, na?
Yes, Your Lordship.
And Ms.
Fine.
Sharma
I am for respondent number 2, my.
for 2. And the other respondents? And so is all the respondents present today? Because I find some AD cards probably are not
I
back.
mean only is.
Huh?
item number
That was,
16.
my lord, in respect of 17, my lord.
So who's appearing for 17? Is it there right
I
now?
am getting-
17, I'm appearing for respondent number 5, Your Lordship.
Are all the respondents represented now? Yes, Mr. Counsel. Have you seen the office notes or not?
In our case, my lord, it was completed, my lord.
Completed. And in your case?
No, item 17 is not represented today, my lord. So we are not that.
She's appearing for 17.
For respondents, my lord. Appellant is defined. Appellant is defined.
Oh, appellant is not there today.
Lord.
Why are you that side? Huh? That's why the confusion. Huh? Mr. Sharma, you are unnecessarily causing a confusion. Mr. Goswami, no? Huh? By default.
I'm not too sorry.
So what is to be done then? The service is complete, mediation is failed. Hmm? Mediation report is already there.
But in our case, my lord,
What happened before the mediation? Not appeared. Mediation report to বেলেগকে আছে নেকি ইয়াত নাই flag X বুলি থাকিব নেকি
There is a mediation report.
yes it's marked as flag X what is to be done today Mr. Goswami yes
My lord, matter is fit for hearing, my lord.
hearing
Lordship.
Your lordship, we seek your liberty to file a cross objection in this.
okay then you file whatever you want to file the
Matter is
mediation
fit for
process.
hearing in the meantime, my lord.
Huh? Mr. Goswami, just have a look if the mediation report is there. Kamal Didya. They can talk Didya. Heard Mr. R. Ali, na?
Lordship.
Learned counsel appearing for the appellant in item 16. Hey, but hey, to DD, put a reference to me. Item 16 episode Nilikhiba. And Mr. M. Goswami, learned counsel appearing for the appellant in item 17. Also heard MS B. Sharma. Sorry, L. Sharma. Can you please ask one of the junior counsels to give all the names of all the respondents in an appearance slip? So, against both the matters, 16 and 17. The office note indicates that the mediation though was attempted between the parties, however, the same could not be done. However, the same could not borne out any fruits. Stop. The matter can, MS, your name please? Aviani seeks a short accommodation to file cross objection. Prayer is not opposed, released on such and such date. You file it first and then we'll fix it for hearing. It's not there. The office note indicates, so I mentioned it. But that's a fact, right? The mediation failed, isn't it? You all are aware of it. Mr. Ali, you're aware of it. Correct. The office note only. Ms. Sharma, are you aware of the mediation proceedings or not?
No, my lord, I am not aware.
We can also report.
All right. The though office note indicates the mediation has failed. However, the report is not available on record. Let registry verify and place the report on record. Tarpisot teketor.
Item 18.
Wait, please.
Second appeal.
Wait, please.
Service.
Yes, lordship, as per office note dated 5/2/2026, there are sole service upon sole respondent is that the respondent refused to accept the notice.
Oh.
And as such, the notice was affixed on the front fence of the house of the respondent. The lordship, it may be deemed to be served.
Your name?
Miss K. Bora.
Heard MSK Bora,
Yes,
learned
Lordship.
counsel appearing for the appellant. Office note dated 5/2/2026 indicates that the sole respondent refused to accept the notice, and accordingly, the notice was affixed on the front fence of the house. Considering the report of the office,
Process.
the service in respect of the sole respondent is deemed to be completed. Matter to be listed for, I think, for hearing now, isn't it?
Yes.
Let the matter be fixed for hearing on such and such date. Did you date it?
Obliged.
12th of March.
Obliged.
Item 19.
Dusty affidavit is fine.
Service.
You are appearing. What about one?
They refuse, rather than the respondent, lordship receives the notice.
That is there in the affidavit.
Yes,
Huh?
Your Lordship.
Yes. that's-
That page number 77. Para number 3.
Oh, it was given to the brother.
Yes.
So, you are Mr. Rahman? Heard Mr. A. Rahman, Learned Counsel, appearing for the appellant. Also heard Ms. R. Chaudhary, Learned Counsel, appearing for respondent number 2 and 3. It appears from the affidavit, from the dusty affidavit filed on 6/11/2025, that since the respondent number 1 was not found at home at the time of effectuating service upon telephonic information received from him to serve it to his brother, the same was handed over to his brother Poonam Sharma, who has accordingly received it. In view of the said averments, the service in respect of the respondent number 1 stands complete. Today, when the matter is called, there is no appearance on behalf of respondent number 1. Let the matter be refixed on such and such date. We will wait for some more time and then fix it for hearing.
Respondent is suffering from
Okay,
cancer.
since the matter, it further appears that the TCR has received in the matter, that the matter be fixed for hearing on such and such date. আগৰ matter-টোত TCR পাইছে নাই চাই ল'বা, যদি TCR পাইছে এইটো লিখি দিবা, নাই পোৱা যদি আকৌ hearing হ'ব।
26.
Yes, next please.
Item 20.
Yes.
Lordship, matter may come up after 4 weeks, Lordship.
Why 4 weeks?
Lordship, we could not communicate with our client.
Communicate what?
Lordship was directed to take steps, Lordship.
To take steps.
Lordship.
You are not being able to take steps till now.
Lordship.
Why?
We could not communicate.
What communication you need with the client? You take the steps. You are the counsel on record.
Lordship,
They
might not be interested.
Why will they not be interested? They have engaged you.
Lordship,
They have done their part of the job. They have engaged you.
Thereafter,
They have exercised they have exercised it diligently by engaging a counsel. You have filed the regular second appeal. The court have issued notice. Why are you not taking steps? You have to take steps. You take your steps.
Lordship, after 4 weeks, Lordship.
No 4 weeks. Your name?
F Intaz.
Heard MSF.
Intaz, Lordship.
So and so learned counsel Intaj, learned counsel appearing for the appellant. It appears that the steps as were directed by this court by order dated 9/8/2024 is yet to be taken. MS Intaj submits that due to non-communication with the appellant, the steps could not be taken. Be that as it may, let the steps be taken within a period of 10 days from today.
Is it also connected? It may also be text.
Mr. Bhattacharya, please don't interfere when the court is dictating. Mr. Bhattacharya, you could have said it before it or after it. Do not disturb the flow of the court. Have patience. As so and so submitted. Within a period of 10 days and relist Korea after 2 weeks. And yes, Mr. Bhattacharya, you are appearing in this case.
Your name is there in the.
Okay, all
We have
right.
not received, we have not been served. And item 46 is the same matter.
So you would you be appearing for the respondents otherwise?
How the papers?
No, I'm just asking you, are you otherwise I will not say anything because she has not taken steps. So I will fix it on the same day. I'll fix it on the same date, but I'm not saying anything. All right? Because they have not done anything. Ekeda did you? You take your steps within 10 days. Otherwise, I'll dismiss it with cost. Yes. Same day. Yeah.
Item 21 and 22.
No, 46 such steps লৈছে নেকি? 46 to মাতা নাই এতিয়ালৈকে?
Connected.
যাও, thank you. গ'লগৈ নেকি? এইটোতো নোটিছে হয়, huh? She's left, no? Mr. Bhattacharya, item 46, even notice has also not been issued. No, no, that's all right. No, take it matibo para niki.
Our note says that.
All
we are
right,
the same
all right, all
respondent.
right, all right. Your notes may say anything. 1 second. The court has not issued notice. Have you filed any caveat here? You have not filed a caveat. Take your seat, Mr. Bhattacharya.
16 and 17.
You take your seat. এইটো একেই নহয় হা, এইটো নোটিছে ইস্যু হোৱা নাই এতিয়ালৈকে। থৈ দিয়া মানুহজনী আহিলে মাতিব লাগিব এইটো। Call the next matter.
21 and 22. Item 21 and 22.
Next matter.
Item 23.
May I please, Your Honor? My lord, kindly see the office note dated 6/2/2026, my lord.
Yes.
Notices as well as service reports.
Just 1 second. গ'লগৈ নেকি? Numberটো পাবা চাগে, আজিকালি number দিয়ে নহয়, then give her a call. Because yeah, give it because in that matter that's a fresh matter. Notice issue hone gaye. So how can we just notice to issue kore lobo lego? Yes, please. Office note 62.
6/2.
Await service. Await service. You are appearing for
Lordship, 1E and 1F.
1
E and 1F.
Okay.
Lordship,
Yes, yes.
Lordship, the delay is for only 2 days.
This is a delay condonation.
Yes, my
Yes,
lord.
Your Lordship.
2 days.
2 days,
Yes,
my
Lord.
lord.
I'll condone it then.
Yes, Lordship.
Yes, my lord.
And who are these 1 BA, 1 BL, 1 CA? Who are these respondents?
My lord,
Who are these respondents?
legal share of Azira Khanum.
You are EF, na?
Yes, Lordship.
So you are the sons and daughters of late Mustafa Uddin.
Mustafa.
And the others are, so they are all. The problem is that they're all the legal heirs.
Yes, my lord.
And all the notice have not. But anyway, this is for condonation of filing what?
Regular second.
Okay. Heard, Mr.
M. Hussain, my lord.
M. Hussain, Learned Counsel, appearing for the applicant. Also heard MS. J. Sharma, Learned Counsel, appearing for the respondent 1E and 1F. It appears that service, despite steps having been taken against disposed নাই কৰা দেই. Mr. Counsel, there are so many notes of the office.
Yes.
So you've been given last opportunity to take fresh steps, not once, more than once. Why are you not taking steps against these respondents?
My lord, after Lojima court order dated 28/4/2025,
Yes,
my lord, I have taken steps, my lord.
you have taken
Yes,
steps. That is not reflected here. So your Mr. So-and-so submits that after the Lawazima court's order dated 28/4/2025, steps has been taken in respect of respondent numbers 1BA, 1BB, 1BC, 1 BD, 1 BE, 1 BF, 1 BG, 1 BH, 1 CA, 1 CB, and 1 D. However, none has appeared till date. Give me that. In support of the aforesaid, he places the acknowledgement receipts. These are only two acknowledgements.
Register and the usual process.
One indicating registered post and no, receipts. Stop. I think I would have condoned it, but probably the registry needs to have a note on this. Otherwise, it might create a prejudice. Even 1 day delay may matter. Let registry verify and place a report thereof. Relist on. I'm posting it on Friday. Let registry give a report. You place this before the registry. On Friday.
Item 24.
What about steps for 1 and 3?
Steps.
Yes, Mr. Mahmood.
Well, please.
No steps for service of notice in respect of number 1, 2 has been received. Neither AD card nor unserved for 1 so and so. But what about the step for 1, 2? Have you taken or not taken? Just yes or no, please tell me that.
It seems that yes, step has been taken.
1, 2.
That is not clearly mentioned, but
So then you do whatever is to be done. Heard Mr. M.U. Mahmood, Learned Counsel appearing for the appellant. Office note dated 5/2/2026 indicates neither AD card nor unserved notice having been received from respondent numbers 1, 1, 1, 3, 2, 3, 1, and 3, 2 till date. It further appears that no steps for service of notice in respect of respondent number 1, 2 has been taken by the appellant till date. However, Mr. Mahmood submits that the steps in respect of respondent number 1, 2 has been taken. So have you taken or not taken? Your submission I'm recording.
It is taken, but
Let registry verify and place a up-to-date report. Relist after a week.
already.
On 20. 25.
You are appearing for all respondents.
I'm appearing for respondent 1 and 2, and I'm respondent number 3 in person.
Respondent 1, 2,
and 3. I'm 3 in person.
You
as
are
well.
you are appearing for 3 in person.
In person, yes.
You are Rasul.
I'm Mr. Rasul, yes.
But if in person, my lord, then
Yes. You're not in the proper attire.
I know. But I have signed a wakalat number for myself.
How
But
can
if
you
I
sign a wakalat number for yourself?
I can provide an affidavit, or I can change my.
For yourself? How can you sign a wakalat number for yourself? Anyway, these are things you should be, the judicial time should not be wasted for you. You know what is to be done. So please do what is to be done.
Absolutely.
You can, if you want to continue appearing in person, then I can take it up after the next matter. In the meantime, you be appropriately dressed. Next matter.
6.
My son is now out of station, my lord. So
You want some time?
a day after tomorrow, my lord, maybe pick.
Ms. Sharma, why is this matter today?
It's not yet admitted. It should be come up for admission.
It's a RFA.
Yes, Lord.
Okay, as prayed for on behalf of Mr. R.I. Bhunya, Learned Counsel appearing for the appellant who is out of station. relist on such and such date. DD1 number. Super. Yes, next.
Item 27.
May please, Your Lordship. My lord, in this matter, we have filed one I on 5th of February, my lord.
IA for what, Mr. Deka?
For the stay of the execution process, my lord. So may I pray, my lord, execution date fixed on lower court in the 13th of February. Can it be before any 13th, lord?
You want to file an objection? Huh?
No. It's it.
No. So you don't object to the prayer made in the IA? You don't know. Huh? I can't hear you.
Yes, Lordship.
You don't know. Who's your senior?
MJ Gadi.
Huh?
MJ Gadi.
MJ?
Gadi.
Where is he?
Right now.
What instructions did he give you?
Clean
No instructions.
Let I come if they file objection.
But what is why the standard of the bar is coming down to such a level? The council has no idea what is to be done, what is to be said. Yes.
Just give me something. I will get.
Perhaps he's not aware of this subject.
That is no, I understand the
Yes.
predicament, but this is not the way. You are an officer of the court, right? So next time you are asked to appear before a court, take some responsibilities. Do not just come and appear before the court. If your senior wants you to appear, then you find out what is the proceeding for and if there is anything to be done in the matter. Now, if they are filing an IA for staying the execution proceeding, perhaps you will file an objection. And if you do not have any objection, I can dispose of that IA. There is no requirement of keeping that matter on another date in the event you don't want to oppose it. That is why this court is asking, do you have any objection? But you do not have that instruction right now. Anyway, Learned heard Mr. P.K. Deka, Learned Counsel for the appellant, also heard MS. S. Ahmed, Learned Counsel, appearing on behalf of Mr. M.J. Kadir, Learned Counsel for the respondent. Mr. Deka submits that the interlocutory application, is it already on board?
Not in the record, my lord.
An interlocutory application has been filed for staying the execution proceedings. However, the same is not on record. Let the RSA along with the interlocutory application, if numbered, be listed on
11th, my lord.
on such and such date.
Deeply obliged.
Item 28.
Yes, Mr. Gupta.
Steps taken, Dr.
Steps taken. You are appearing for all.
Some has been unserved. We'll take fresh step again.
Okay. It appears, heard Mr. Gupta, Learned Counsel, appearing for the petitioner. Also heard Mr.
H. Ali.
H. Ali, Learned Counsel, appearing for respondent numbers
2, 3, and 5.
2, 3, and 5. The office note dated 6/2/2026 indicates neither AD card nor unserved notices having been received for respondent numbers 1, 2, 5 to 7 till date. Mr. So-and-so seeks an opportunity, submits that fresh steps shall be taken against the aforesaid respondents. Prayer is allowed. Relist on such and such date.
On 25th. That being item 25.
My lord, since the matter is the main case, my lord, since matter has already been, notice has been served and matter is ready as regards service as well as LCR, my lord. So may I pray that since he is appearing in person, a date may be fixed for final hearing of the main second.
So
appeal.
you have filed a second appeal.
Yes.
Substantial questions have been framed already.
Yes.
That has been framed.
Yes.
And what is this IA for?
IA actually, one IA is for stay, one IA for injunction. Now injunction IA is there. So if entire matter is heard.
So now they have entered appearance
Yes.
in all of them.
All of them.
Any objection filed to the IAs?
No, they have.
Yes, my lord, I filed an objection on 6/2.
You have filed.
Respondent number 1 has filed.
So you may, now what do you want? Do you want all these matters to be heard together?
Yes, yes. They are at a final hearing, my lord.
All right. Heard Mr. S.K. Ghosh, Learned Counsel, appearing for the petitioner. Also heard Mr. M.D. One second. M.D. Istiaq Rasul, who is appearing in person for respondent number, stroke respondent number 3, as well as on behalf of respondent number 1 and 2. Mr. Ghosh submits that the second appeal, along with the IAs, be taken up for final disposal. Relist the matters for hearing on such and such date.
My lord, 10th of November. My lord, in the meantime, a copy of the objection may be served on this.
Already been served there.
Yes.
Fine.
Then, yeah.
You sort it out, Mr. Ghosh.
No,
If they file, they have to give you.
Yeah.
Without giving you, the registry will not
Will
accept.
yeah.
In this item 46, it appears there is no notice yet issued. So I will issue notice. Okay. An item 46 issue notice kori diba and ticket naam to lilo. Issue notice aro steps 3 days. 10 days I'm giving you since you don't know your clients, you said. In this you know or you don't know? 4 days. And relist on dated date.
Item 29.
Review, Mr. Das.
Basically facts, Lordship.
IA for allowing review.
Lordship, we were not petitioners in that party in that big petition, Lordship. That's why.
Yes.
The facts of the case, Lordship, is that with respect to a particular plot of land under the ASTC Johar, Lordship, a tender was issued. The respondent number 1, she participated, and thereafter she was allotted that premises, Lordship. But Lordship, she couldn't take the possession of that particular premises because Lordship, we, the current petitioners, were holding that particular plot, and we were running our small.
Today it's coming up for the first time.
First time, Lordship.
So you
will respond.
So,
but the prima facie they have failed to make any ground for review.
That's all right. We will issue notice. It's come for the first time.
Should you just allow me to make one submission?
Yes, Mr. Das.
Our prayer is limited to one thing, Lordship. Just we want a clarification with respect to the facts which were placed by the respondent number 1 when the read petition was there. Lordship, order was taken from this honorable court by completely pressing some facts which were not true, Lordship. We were projected as encroachers, Lordship, but whereas Lordship, we were giving our due payments to the ASTC and we were running our shops. Now, Lordship, the tender is not a subject matter here, Lordship. We have challenged the tender proceedings in a different read proceedings, Lordship. So, Lordship, just to support and clarify on this aspect, we have filed this review. Lordship, just that ASTC is required to clarify on this aspect. Lordship.
Where is my order?
Lordship, page 59, Lordship.
61.
Lordship, 59, it starts, Lordship.
Yes. Which part of my order you want clarification?
Lordship, para 9, Lordship.
You are appearing for the ASTC.
Yes, Lord.
You are appearing for ASTC.
Lordship, para 9, it states that, may I read, Lordship?
Yes.
It appears that because of encroachment of 9 numbers of shopkeepers in the subject area, the respondent ASTC Jorhat division could not allow the.
According to you, you are not encroachers.
Lordship, they have issued a tender, Lordship, for a plot of land which is already occupied, Lordship. They did not take any eviction.
Occupied, my lord.
But how is it prejudicial to you, Mr. Das? Because we have not given any finding as such.
Lordship, just that, Lordship, since we have challenged.
From because you are not even a party here.
Lordship, we didn't even.
Why are you inviting an adverse finding against you by making yourself a party in this proceeding?
No, Lordship.
You are not even a party.
Lordship, but since we were projected as encroachers,
yes,
since we have challenged the tender.
So there you show that you are not encroachers because
they are not encroachers.
Mr. Counsel, would you allow the appellant first to argue? I'll come to you. It's you are not a party in that proceeding. Are you a party in that proceeding? Then,
Only after.
then where is a decision that you are an encroacher? Is there a decision taken by this court that you are an encroacher? Is there a hearing done on that basis?
No, Lordship.
It is a mere observation.
Lordship.
You are not even a party.
Lordship. But
Then-
Lordship, since the word encroachment was used.
Whatever has been projected on that basis, it was given.
Lordship.
If you are not an encroacher in an appropriate forum, you project yourself, you show your case.
Lordship.
And what document you are trying to now bring by way of this review application to show that you are not an encroacher?
Lordship, we have annexed certain pay receipts, Lordship. Start from page.
What pay receipts?
Lordship, that we were giving it to the ASTC, Lordship. ASTC was collecting monthly.
We don't know. That is not an issue before this court.
Lordship.
These are not issues before this court.
After this court passed this order, Lordship, the eviction drive was carried out by the district administration. Then we came to know about this tender process.
No. Then you individually, you could have filed a case.
Lordship, we have filed that notice has been issued. It has
Very
been
well.
pending, Lordship.
But
Lordship,
here, and it says this petition was filed by whom? Who is the petitioner here? Ms. Kakati, you were the petitioner. Your case before this court was that to hand over the vacant and peaceful possession of an area. That entire area was yours, where there are shops. And some people have been, according to you, some people have encroached and were running shops there. That is your case. And what is ASTC's case?
No, we have issued tender and the place has been allotted to the highest bidder. That's it.
Now, in that writ petition, the encroachers were not a party.
No, they don't have any say on this. They were temporary occupier there, installing some temporary pawn shops and all. They don't have any agreement with the ASTC paying rent and everything. They're not our tenant.
They are not your tenant.
No, not at all. They cannot, by installing a temporary shop for which they are paying some amount according to the receipts. I don't know whether it's correct or not.
Mr. Das, you have already filed a writ proceeding. Suppose I dispose of this review petition by saying that the word encroacher, that observation in para 9 is not binding in that proceeding, and that proceeding will proceed in accordance with law. Then, because we have not given a finding whether you are encroacher or not. It was a simple, I think, disposal, isn't it?
Right.
In view of the aforesaid, this court deems appropriate in the interest of justice to dispose of this writ petition by directing ASTC to take necessary measures with the help of district administration to remove the encroachers from the so-and-so. Now, if there are someone who is not an encroacher, he will take his case in accordance
Yes,
with law.
and that has been done.
Right.
It was followed. This direction was followed. They were called by the magistrates.
I don't think, I'm sorry, Mr. Das, no case of review is made out.
Then leave it to your lordship.
No
We
case
were
of-
here with respect to the.
There is no error apparent below.
No case
We
of.
were only here with respect to that word encroachment which has been used.
Yes, but you see, what is the order?
Lordship.
It says in the interest of justice, disposed to take necessary measures so-and-so to remove the encroachers. So if there are encroachers, they will remove it. Now, if you are saying you are not an encroacher, then you project a case before the court, which is the writ petition that you have filed.
WBC 6681. Lordship.
Okay. I'm disposing of this, huh?
Okay.
Heard Mr. H.R. Das, Learned Counsel appearing for the petitioner. Also heard Mr.
H. Omamila.
A. Samuel, Learned Counsel appearing for respondent
3 to 7.
3 to 7, no? Standing counsel, I also standing
Yes,
counsel.
standing counsel. Yes.
Learned Standing Counsel Corridor, ASTC, within bracket, respondent number 3 to 7.
7.
And MS Kakati, Learned Counsel appearing for respondent number 1. Yes, for transport. RB Goswami, respondent number 2, transport. By way of the instant review petition, the petitioner is seeking review of the judgment and order dated 29/10/2024 passed by this court in WPC 4555 of 2024 to the extent that the petitioners have been described as encroachers in the said order. Stop. Which is the, Mr. Das, where is the order giving you liberty? That IA order you said? Take your seat, Mr. Das. In the connected writ petition, WPC 4555 of 2024, the respondent number, Ms. Kakati, you are respondent number 1 stroke petitioner sought before this court to hand over the for a direction to the respondent authorities to hand over the vacant and peaceful possession of an area of 400 square feet at ISBT as described in the NIT dated 2/1/2024. After hearing the respondent number 1 stroke petitioner and the respondent ASTC, this court disposed of the said writ petition by observing as under quote unquote para 10. It is submitted at the bar that pursuant to the direction passed by this court, the respondent ASTC has.
We have followed the instructions, my lord.
No, you said you had called them and you had.
Yes, yes. Lordship.
What have you done? Just indicate that. I'll put it in the order.
They were called by the district magistrates. The hearing was taken place. Then the final decision was.
That the encroachers in the subject length, including the petition, including the review petitioners, were called, and after hearing the persons, the order of eviction was passed. It is at that stage the review petitioner approached this court by filing an interlocutory application seeking leave to file the instant review, which was allowed by this court by order dated 8/9/2025. IA2 being IA Civil 3756 of 2024. Mr. Das submits that the observation made in paragraph 9 describing the review petitioners along with others as encroachers in the subject area is causing prejudice and detrimental to their rights without they having an opportunity of defending the same at the time of consideration of the writ petition. He further submits that the review petitioner, how many of you are there? Totaling so many in numbers, have already filed a writ petition being WPC number
6681 of
681 of
6681
6681 of
2024.
2024. And how many of them?
Lordship, 4.
4, huh? Before this court. And what is your challenge in that writ petition?
Lordship, we have challenged the tender, Lordship, dated.
Challenging the subject tender issued by the ASTC. Stop, huh? Mr. Samoria, learned counsel on appearing standing counsel ASTC on the other hand submits that the review is not maintainable as there is no error apparent on the face of the record committed by this court while disposing of the writ petition by the judgment under review. MS Kakati similarly supports the contention of the learned standing counsel ASTC. Having heard the learned counsels appearing for the parties, it appears that this court has not decided Mr. Das, what are those documents that you want to say that 65A? These are the ASTC.
Lordship, these are the challans, Lordship. Even after issuance, Lordship, I just wanted to show that even after issuance of the allotment order to the respondent number 1, our review petitioners were paying them monthly dues, Lordship. It shows, Lordship, of 4,724 also, monthly installment, Lordship, minimum fee, Lordship. So due permission was taken from the ASTC to sit on that particular plot of place, Lordship. Now ASTC issues a tender notice on the background, Lordship, without informing us, without publishing it. That we have taken care in the writ petition, Lordship. But here just
that you have taken care of what?
Lordship, that NIT has been, we have filed a case against that in the writ proceedings. But here, Lordship, just that we were projected as encroachers, even then, Lordship, after the tender process was completed, we were paying, Lordship, the monthly fees and so Lordship, encroacher is someone who is not having any legal background, Lordship, without the due permission if someone is sitting.
Now, Mr. Das, the problem is because it has been submitted on behalf of STC that you all have given an opportunity of hearing. In that hearing, you have already participated. You have submitted your documents. They have verified and they have given the order of eviction. This is what I think has been submitted.
Yes, Lordship.
Now, if that exercise is done, then you are not prejudiced.
Lordship, no hearing. I don't think any hearing was taken place, Lordship. After the issuance of this order, Lordship, Annexure 364,
Then
Lordship. The additional.
What is it? What is the stage right now? Are you still occupying?
No, Lordship.
You have been evicted?
Lordship, we have been evicted, Lordship. So that was my case, and Lordship, Annexure 3, page 64, Lordship. This is an order passed by the additional district magistrate, pursuant to the order passed by this honorable court, Lordship. Following that, you are hereby directed to appear before the undersigned on so and so for smooth execution of the Honorable High Court's order, Lordship. Nothing mentioned about hearing in this.
No, but an appearance was given.
Lordship. Lordship, we had to follow, Lordship. After Honorable Court's direction was passed, we had to follow, Lordship.
So you appeared.
We appeared, Lordship, but.
And there's, do you have anything to show that they had been?
Right now, I do not possess anything, but after giving them an opportunity, the rest action has been was taken. And they are now not in the possession of the particular plot of land, a particular portion of the land. It's 400 square feet according to him.
Lordship. Even if the opportunity is given, Lordship.
They have already filed the writ petition. If my learned friend is saying, the writ petition number is 668125.
See, Mr. Samuel, the only difficulty I'm facing is, you see, in paragraph 10 of this court's order, inadvertently verification is not mentioned. Now, they may be encroachers, we don't know. They were not parties. They were not parties in this writ proceedings, right? And this court, by way of this direction, we have directed you to take actions against the encroachers. Your letter also indicates that you have asked them to appear before you. Suppose you show us something that an opportunity of hearing was given, then it would take care of it.
But
Because you see, Mrs. Samuel, after I dismiss this review, the next step would be an appeal. Are you understanding what I am saying? Because it is indicating the way things have come, there could be a possibility of saying that this was done without giving them a hearing. But if you can give me that some document showing, which you have just stated, that then an opportunity was given to them, and this letter 64 indicates that. But the only thing is that letter 64 doesn't say that you come with your documents in your hand or anything. It says that you appear, is directed to appear before this undersigned on 20th November for smooth execution of the Honorable Court's order.
After that, what happened? My friend should have reduced here.
That is, he's not
After that,
saying.
NHF 5 is there, Lordship.
What?
Notice of eviction as per direction of the.
According to him, after this, it is the notice. No, but what happened in that hearing on 29/10/24? Because according to you, but did they come up with these documents or not?
My lord, if
अच्छा
there
प्रणव की लिखी साहब नहीं लास्ट और फल after hearing no don't say that it appears that pursuant to this court's direction issued to the ASTC, a letter was issued by the additional district magistrate Jorhat to the review petitioners on 16/11/2024, directing them to appear before the undersigned on 20/11/2024. Accordingly, it is submitted that the review petitioner appeared before the district magistrate on the scheduled date. It appears that thereafter, where is Annexure 5?
To page 73.
The divisional superintendent by order dated 27/11/2024 issued the notice of eviction to the review petitioner. Stop. This is not under challenge.
No, it is not.
You have not.
Lordship.
You have not challenged. It is submitted at the bar that the notice dated 27/11/2024 is not put to challenge before any competent forum. Though Mr. Das, by placing reliance on the receipt for payment to ASTC, submitted that the review petitioner have been paying rent, rent to the ASTC for on account of the shop. It is apparent that the shops were temporary in nature. Considering that the review petitioner have already been afforded an opportunity before evicting them pursuant to the direction of this court, this court does not this court does not find any merit for reviewing the order of this court. Accordingly, the review petition stands dismissed. However, it is clarified that in the event the petitioner, don't say that. There is nothing otherwise. Your temporary shops, your own receipt says.
Just that, how can we be projected
After paying that?
We are still paying that receipt, Lordship. Monthly fees we are paying. Then how can we be projected as encroachers, Lordship? We are holding those temporary shop by due permission of the ASTC, Lordship. Simultaneously, ASTC issues a tender notice, Lordship. They complete the entire proceedings.
Though it is submitted that since the petitioner have been paying rent to the ASTC, they could not have been termed as encroachers, considering that the review petitioner has already challenged the tender issued in the just give that tender details, so and so in the writ in a subsequent writ petition, the matter being at large before the writ court shall be, this court shall not not give any, shall not comment on it. However, it is clarified that this court had not decided the issue of whether the petitioners were encroachers or not in the earlier writ petition, and only on the case projected a direction for eviction upon verification was issued, which the authorities, after giving due opportunity as appears from the review petition, has been undertaken. I think that will suffice. I'll edit it later.
No, sure. Obliged.
Item 30.
It we are fine.
Objection file to leave. Objection file to
Item
May
30.
may it please, your lordship, this is the condonation application, delay of 3043 days.
Delay of 3043.
What happened, my lord, after passing of the award, insurance company has preferred review application. And review application was, after review application was rejected on 2/11/2024. Thereafter, the appeal was filed. That's why the delay occurred.
The delay occurred because of the pendency of the review.
application.
Any objection?
Not objection is there. I will file objection. This is a in fact,
Serious
a cross-
objection.
It is a cross appeal. In fact, my appeal was filed in 2017, and after that, but they come after.
But the review was pending.
No, my lord, the review
Review
was
was
not immediately
on the
filed.
ground of
Review
fraud,
was
my
not
lord.
immediately filed. I am coming to all record, my lord.
Huh?
Review was not filed immediately. my lord.
No, my lord, review.
How
was-
much time was taken for review?
Judgment was passed on 27/10,
Judgment is-
2016, my lord.
27,
10, 2016.
10, 16.
And review was filed after, when we got the knowledge of the
When?
fraudulent award,
When?
2/3/2017, my lord.
After 1 year.
No, 27/10/2016, my lord.
No, no. Judgment is
Ju-
27, 10,
Yeah,
16.
16.
And review
2/3/2017.
2nd March
Yes, my lord.
17.
17, my lord.
I think, and when was the review finally decided?
The review was rejected on 2/11/2024, my lord.
2/11,
2024.
24. And this appeal has been filed when?
28/2/2025, within limitation.
28?
2/2025.
Yes, these are the facts.
But my
Condonation is a discretion of the court.
is all right. my
What
lord.
is, I don't find anything malafide or dilatory in approaching
No,
the
my
court.
lord, this is a.
They have immediately filed a review. Review was pending. What can be done?
My lord, the review.
You see, I am not deciding on the merit. Isn't it, Mr. Mohanto? Only thing I'm deciding is the condonation. Why should I foreclose the right?
The review power,
We are-
is not, but the review power is not interested in the tribunal.
Maybe,
The law firm has-
whatever. It was
But the-
pending.
But the thing is that.
You
it's a
see, the
cross-
fact is that they have immediately preferred review, filed a review. After the review was rejected, also they've immediately come within the time limit. So I think it's all right.
But unnecessary, it is my delaying these things. My appeal was filed in 2017.
It's all right.
So my one short date may be given when I filed.
I am allowing it.
3043 days delay there.
Delay.
But the
Number-
all right, my lord, but thing
You
is that
see,
so
the
far-
number is not material.
But
The explanation.
But the thing is that, my lord, they, when they were from the date of the judgment,
All right, you file your objection. Heard MS Esrai, Learned Counsel appearing for the applicant. Also heard Mr. Mohanto, Learned Counsel appearing for?
1 and 2 respondent, my lord, but the 3 and 4 is expired.
Already stuck.
But that is
Struck off, right? Huh. So and for the respondent, huh?
Well,
Mr. Mohanto seeks 2 weeks time to file objection in the matter praise allowed post on such and such date.
sir.
Yes, 8 days delay.
Item 31.
Mr. Khan?
Yes, yes.
8 days.
Only 8 days.
Yes, Ms. Sharma.
No, that's a matter.
Heard Mr. A.M. Khan, Learned Counsel, appearing for the applicant, sorry. Also heard Ms. L. Sharma, Learned Counsel, appearing for
Respondent number 1 and 2, my lord.
respondent numbers 1 and 2.
Insurance.
And as far as the service report, your lordship,
So, office note dated 4/2/2026 records as under quote unquote in respect of 3, 4, and 5. A to A kori diba. In view of the efforts above service note, service can be deemed complete because they have already received through someone, isn't it?
yes.
3 has been was not at home and notice was instead received and signed by the brother. 4 was received by an employee and 5 was not at home and received instead by his brother. Deemed complete. By way of this application, the applicant is seeking condonation of delay of 8 days in filing the connected appeal under. Where is the main appeal? It's not here. Main appeal to BJP.
Your number is 2909/2000. Okay.
Under Section 173 of the MV Act 1988 against the impugned order dated 29/10/24 passed in MAC case number 368/2022 by the learned member Motor Accident Claim Tribunal, whereby the Gwalpara, Assam, whereby the claim petition of the applicant has been dismissed. It appears that a delay of 8 days occurred while filing the instant application, primarily on the ground of taking steps in furnishing the relevant documents and the preparation thereafter consumed in filing the appeal. MS so-and-so fairly submits before this court that she has received no instruction to object to the condonation. Having heard the learned counsels for the parties and having perused the grounds of condonation, which appears to be sufficient and bona fide, the delay stands condoned. MAC appeal to be registered and numbered, disposed of. Yes, 48 days. Any objection?
No, no.
But what about 2 and 3? You are appearing for?
Claimant, respondent number 1.
1. So main is 1 only, isn't it? 2 and 3 are the insurance. Who has 2 and 3? You are the insurance company. This direction is for giving the money to whom? To the claimant. The claimant is already represented. Heard MS A. Biani, learned counsel for the applicant. Also, it will main group of main case. Also heard Mr. So and so learned counsel appearing for the respondent claimant. By way of this application under Section 5 of the Limitation Act, the applicant is seeking condonation of delay of 48 days in preferring the connected appeal filed under section 173 of the MV Act so and so against the judgment and award dated 3/10/24 passed by the learned member MACT number 2 Kamrup M Gauhati in MAC case number 2077/2019, whereby a sum of rupees 4,14,269 was awarded to the claimant to be paid within 30 days from the date of judgment, together with interest at the rate of 9% per annum from the date of filing of the case I 23/9/2019 till realization. Stop. It is contended that the delay of 48 days occurred primarily due to the steps consumed for obtaining certified copy and engaging the and the decision taken thereof to prefer the appeal and thereafter handing over the papers for filing, etc. The Mr. So-and-so does not oppose to the condonation prayer made. Upon hearing the parties and having perused the materials available on record, the grounds of delay appears to be sufficient and bona fide. Delay accordingly condoned. Corrected MAC appeal to be registered. Disposed of.
Much obliged, Lordship.
82 days delay. Yes, you're appearing for all?
1 and 2.
1 and 2. And you?
For 3.
For 3. Who's for 4 and 5?
5 is the insurance, Your Lordship, and 4 has been the service has been completed, Lordship, as per office and dated 5.
So we'll wait then. The insurance is not here.
Yes.
Await service in respect of respondent number 4 and 5. Relist on such and such date. Give your appearance, huh?
Second.
Yes. 539 days.
Yes, Your Lordship.
Notice issued, not issued.
Your notice, Your Lordship.
All right, issue notice.
Delay was caused due to proceeding.
Okay, I'm issuing notice because notice has not been issued till date.
Yes.
Issue notice. Repost on such and such date. Please give your name, huh, ma'am? Please give your name to the court, ma'am. Yes.
The 6th.
Yes, Mr. Datta, right?
Yes, Your Lordship.
Datta, 4,637 days.
37 days.
Notice not issued.
Notice has been issued, but as per the office note dated 5th of February, the notice upon respondent number 1.
All right, we'll await.
Yes, Your Lordship.
Await service in respect of
Respondent number 456.
456.
Your Lordship, there is a respondent number 7 also, but nothing has been.
So await service. Await service to the court. Repost on such and such date.
Obliged, Lordship.
482 days.
482.
Last occasion, time was taken for filing written objection
By whom?
by the respondent on the.
Yes, you are appearing.
Yes, Lordship, our objection has gone for vetting, Lordship.
What objection?
Lordship, the cause of action, Lordship, of this matter.
Cause of action? We are on limitation. Isn't it?
Yes, sir. Only.
Yes, we are on limitation. You have any objection for the delay?
Yes, Lordship. Since
Serious objection?
it has gone for vetting.
Serious objection?
No, Lordship.
No, not serious. Then I will condone the delay. Mr. Bhattacharya, you are appearing for someone?
My lord, the state is in possession of the land. And there is a 60, in the actual case, the RFA.
All right, we are
60
not,
years of-
we
60
are
years
not
of
going
delay.
into the,
60 years of
we are
delay.
not going into the merit right now. As far as this case is concerned, this is an application for
There's a hospital
condoning delay of 482 days for filing a regular first appeal.
So there's a hospital there. So the
Very well.
health department is filing an objection.
You are health.
Yes, Lordship.
He is there to submit on behalf of health.
Lordship, our
Special counsel is there, Mr. Bhattacharya. Yes, I'm allowing it.
but Lordship, it has already gone for vetting. That's why.
Let it go. All right, you file it. Heard Mr. A.K. Hanan, Learned
MJ
Counsel, sorry,
MJ Kadir.
Kadir, Learned Counsel appearing for the applicant, stroke. Also heard Mr. D. Upamanu, Learned Counsel appearing for respondent number
1, 2, and 3.
1, 2, and 3.
I'm appealing for
And
four.
4, Mr. K.K. Bhattacharya for 4. Huh? And Mr. Upamanu seeks a short accommodation to file the objection, which is set to have gone for vetting. A repost Friday.
Speak, Lordship.
Why next week? It's gone for vetting.
Yes, Lordship, but
Monday.
obliged, Lordship.
60. 38.
Yes, Mr. Mahmood, this is that review petition you have been,
Yes.
huh?
Yes.
Yes, what is wrong with this order?
No, there is no wrong, but some matter was concealed, my lord.
This has come for the first time.
Yes, first time.
So notice has to go.
65.
Notice
Yes.
will have to go.
My lord, as per the office memorandum, the
You are appearing
our
for
school should not.
1, 2, 3, 4, 5. You are appearing for 1 to 5. 1 to 5.
1 to 5.
So notice has to go, no?
I have one.
Heard Mr. M.U. Mahmood, Learned Counsel appearing for the review petitioner. Also heard Mr. T. Thakuria, Learned Counsel appearing for respond numbers 1 to 5, right? And issue notice, extra copies take it or koidiva, and remaining respondents speed post kore na ajikali registered.
My lord, as per office memorandum,
And
our school cannot be.
it's all right. We will hear the matter on merit. Repost on such and such date.
Oh,
2 days. Notice has not gone. The problem is notice has to be issued.
Yes, ma'am.
Issue notice. Huh? Your name?
P. Sen.
P. Sen. P. Sen. Huh?
Seni.
S. Seni. S-E-N-I. Issue notice. Repost.
Obliged, ma'am.
40.
First time.
Yes.
Notice.
Notice to go. I am.
5th of March.
Yes. 41.
41.
First time.
First time notice.
Machu.
Notice. Stop notice. Huh? Contradiction notice. 168 days. Yeah, I got to 83 days. First time.
Yes, Your Lordship.
Notice 23 days.
Obliged.
43.
To notice 4 days. Where is the council? But I think notice to issue ko due. Me janai diya. Mr. None appears Kobo Para, Mr. M. Fukar, none appears for the applicant on call. However, observing that there is this IA has been filed for condoning 4 days delay in filing the connected met appeal, let notice be issued. Steps so and so, let registry intimate the learned counsel appearing for the applicant. Let a copy of this order be given to the learned counsel appearing for the applicant for doing the needful. Repost on such and such date. Because no point of keeping this matter pending. Yes.
I don't know what 7.
Mr. Hawk. Service completed.
No, my lord, it is a substantial question of law has not been formulated in this.
Substantial question
Of law.
has not been formulated. But what about the service?
No, notice has not been yet issued.
Not issued. So today it has come for what?
Mala, last occasion, my lord,
Huh?
we filed a IA for stay of the, my lord, the impute resident.
Oh, today it is.
Today it was mentioned in the morning, so it is not on the proper column. It should have been under order 41/11. That is for admission of the.
Oh, okay. So I'll post it on
Friday, my lord.
Friday.
Because the
Okay,
exhibition
okay. Very well. Heard Mr. N. Hawk. I'm sorry, I kept you waiting for this.
No, it's all.
That time I thought because there was a note about surveys. That is why I thought something has to be given. Heard Mr. N. Hawk, learned counsel for the appellant. It is pointed out that the matter has been inadvertently listed in the wrong column today. Repost on such and such date under the heading for hearing under section under rules so and so, order so and so, rules so and so on such a Friday. You have already served a copy of the draft substantial question.
Yes.
It is already
Yes,
part
yes.
of the.
In the form of
Okay.
action.
Okay.
Of-
All right, at 2. Twenty-one and
21 and 22.
no 9 ৰাতিপুৱা কি হৈছিলে শুধু অহা নাছিলে 20 none appears on call, repost on such and such date. This is that matter, Mr. Nath.
Yes, my workman's matter, my lord.
Mm.
As your lordship is, my lord, we have prepared that list of dash and the written arguments, my lord. Taiko copy diya, taiko copy diya. More copy diya, my lord. You take this one, Ravi, you take it. More copy diya. Yes.
Yes.
I'm giving her copies also. My lord, shall I recap the fact or shall I read?
Yes, yes, yes.
Or shall I read this one?
No, you just recap.
Yes, that's what, my lord. Fact is
Read, I will
tiny. Yes. What happened? He's a workman in a jute mill, my lord. Near my another friend's house, my lord. His house there.
That will be near my house also.
My lord.
Yes.
Okay. So though he remained absent from duties, my lord. So shock cause notice was issued to him, saying the reasons why he was absent. What he did.
The jute mill.
Jute mill, yes. Yeah, I think last 3-4 days, I think it's been closed now. It's absolutely sick. It's very pathetic condition of that one. In between also, it was given to somebody.
In that main road.
No, my lord, it is from, it is in Silghat, where from Joklaunda side.
Oh, acha, there, near your home, that, not in Gauhati.
No.
That's what I was wondering, where there.
Or is it fixed rate?
So what happened? He submitted his reply. What he did, he gave a certificate of the doctor, not from the mill, from outside, but the mill guidelines, standing order provides that if there any sickness, anything is there, there's a doctor in the mill. So the mill doctor should give you the certificate. So he didn't do it, my lord. So ultimately, domestic inquiry started. We gave him 3 notices. He received the notice, but he domestic inquiry, he did not participate. Then he was terminated. Thereafter, he filed an application under section 2A before the industrial tribunal, my lord. Industrial tribunal receiving this, my lord. No. For that, my lord, it was sent to the assistant labor commissioner. He sent it to my lord. There also, he submitted by reply also for conciliation. Nothing happened. So he filed an application before the labor commission, labor court, my lord. In the labor court, my lord, we have submitted our reply also.
This is not a reference case.
No, it is not a reference case. It came under section 2A. It is the workman approached, my lord.
Industrial disputes.
Yes.
2 what?
2A surplus 2. Only one. In that book, I don't know whether she will old book might not get. If it is new, or she will get it.
It's new.
Okay. It is easier to find it here.
Anyway,
The third page.
Section 2.
2A, page number 2. 2A,
2A.
bottom, my lord.
2A is appropriate government.
2A is in the workman to the lordship has got 2A.
2A is
Bottom,
appropriate government.
Second page. Dismissal, etc. of an individual workman to be deemed to be an industrial dispute.
Oh, capital 2A.
Capital 2A, yes. Where any employer discharges, dismisses, retrenches, or otherwise terminates the services of an individual workman, any dispute or difference between the workman and the employer connected with or arising out of such discharge, dismissal, retrenchment, or termination shall be deemed to be an
industrial dispute.
Notwithstanding that no other workman nor any union workman is a party to that. Now, subclause 2. Notwithstanding anything contained in subsection 10. 10 means reference by the government.
Yes.
Any such workman as is specified in subsection
Direct
1.
to the labor court.
Yes, my lord. So that way, my lord, is filing application, my lord, it is come before the labor court.
Okay, and then just continue reading.
Yes. May make an application direct to the labor court or tribunal for adjudication of the dispute referred to therein after expiry of 45 days from the date
And in
he has made
receipt
it.
of such application, labor court or tribunal shall have powers and
Yes.
jurisdiction to adjudicate upon the dispute,
Dispute.
as if it
were
were
dispute.
a dispute
Yes.
referred. So the same referral
Same.
jurisdiction it will
Yes,
have.
yes. Two ways it comes.
Okay.
One directly
So
by
now it has come by 2A,
2A, sub-rule.
and this was application was by the workmen.
Yes, my lord.
Now where is that order? That is under challenge, isn't it?
Yes, my the expedition lordship kindly see that order that is in page number lordship will get in my-
162.
Yes. 161 starts.
162.
62 the relevant part from
तुम्हारा type टेबल की बात है top टेबल
162, my lord. The word starts from there.
Yes, discussion starts from 167
Yes, 167. Lordship will find from 167. Can I read, my lord?
during cross examination.
Yeah.
Okay, you read from
decision. Let me
yes,
read from
yes,
decision.
yes,
It
yes.
is better. My
Yes.
lord. Issue number 1 being the crux of the
Miss
case.
Kalita, right? Please take your seat. No, you take your seat. This is a hearing matter. It will take time. You are not on punishment. You sit properly. You sit. That yes.
My lord. Issue number 1 being crux of the case is taken up at threshold. May I come to the previous page and see the issue number 1? Previous page?
Yes, I've seen.
Page 166.
Yes.
Issue number 1.
Yes.
Whether the termination of the workman from the service of the management as per order dated 2620 was by the management authorities illegal without any lawful ground and liable to be set aside. So, the second paragraph. The petitioner of workman was the regular employee of the management and he was serving in a management company for a period of from 1708 to 2620. 12 years are the admitted facts of the case. Workman examined as a WW1.
Mr. Nath, there was a disciplinary proceeding. An inquiry officer was appointed.
Yeah, appointed, yes.
So did you
examine it?
Did you?
He's examined.
No. In case of an disciplinary proceedings in industrial disputes, when an inquiry is held,
Yes.
then you have a choice. You can rely upon your inquiry officer's report. So did you rely upon your inquiry report or you gave up the report?
No. The report was made, but what learned trial tribunal has found that during the proceeding before the labor court, my lord, the report was not produced. Report is there, I've got with me also. That was not produced before the my lord.
No, but validity of the report validity of the inquiry proceeding was held as a primary issue or it was not?
No, it was not. Nobody has taken up that issue, my lord. Because it was.
Are you having Cooper? Do you have the case?
No, my lord, Cooper, I don't have that. No.
78, I think.
Because this management case hardly,
No. I happen to do a.
Yeah, I've seen lordship's name in some of the judgments.
Labor court.
Some of the judgments I've seen lordship's name.
Noyan.
Accessing directly or
At 1979 decision, my lord.
Yes, yes, you have
Yes,
the
my lord has got it. Just give the text. What was good? My lord was. What is the need for the speed is low than labor. Let's see. Most employees. For engineering. For engineering matter logic.
AIR 1975.
My lord, AIR 1975 SC 1900.
What is the citation?
SCC, shall I give SCC? 1975 to SCC.
One sec. Give me the citation.
1975 to SCC 661.
1975.
1975 to SCC 661. 661. The preliminary issue whether domestic inquiry is by the employer. Preliminary issue whether domestic inquiry was by the employer, but when the matter is controversy between the parties, that question must be said in the issue. The one question being known as it will be for the management decide whether it will reduce any evidence before the court of law. If it chooses.
See, because when these matters are challenged, the management has by then already held the inquiry, disciplinary proceeding. An inquiry is held.
Yes.
Now, what happened? That is why these decisions, it has
Yes.
been clarified that you have a choice. You can stick to your inquiry proceedings. Now, in that situation, the validity of the inquiry proceeding will be first considered. If the court comes to a finding that the inquiry is valid, meaning thereby all procedures of natural justice is followed, then the termination can be upheld. Okay.
Yes.
However, if it is found that the inquiry is vitiated for some procedural reasons, in that situation, you can choose. You can say, no, now I want to be, I want to adduce fresh evidence. So then an opportunity has to be given both to the management and to the workmen to adduce fresh evidence in the discipline before the labor court. Now that is why I'm trying to ask you what has happened, because here you are giving me an idea that the termination has been set aside on the ground that the inquiry report was not available. But then the matter could have been at large before the tribunal itself.
Exactly. Tribunal has got the power.
Tribunal has the power.
The power to look all these factors, my lord. Even tribunal will call for that inquiry report also.
Yes, because it is in paragraph 22, I believe. Have a look in paragraph 22.
Of my lord?
Cooper.
Oh, yes.
When a case of dismissal or discharge of an employee is referred for industrial adjudication, the labor court should first decide as a preliminary issue whether the domestic inquiry has violated the principles of natural justice. When there is no domestic inquiry or defective inquiry is admitted by the employer, there will be no difficulty. But when the matter is in controversy between the parties, that question must be decided as a preliminary issue. On that decision being pronounced, it will be for the management to decide whether it will adduce any evidence before the labor court. If it chooses not to adduce any evidence, it will not be thereafter permissible in any proceedings to raise the issue. So this is why I'm asking, because you have given an impression that these matters you are challenging is the termination. They had challenged
They
that
played that.
termination, which the labor court have upheld.
Upheld.
Correct.
Yes, yes. Now the labor code, just please see on page 171. That part actually. 171. About the fairness of the inquiry. There is one sentence I want to read that. 171. Top.
Yes.
The management ought to have produced all the documents of the domestic inquiry. All this has been marked as exhibit. That is incorrect. Report of the inquiry officer, but that is not there. Second, notice on proposed penalty to which he has submitted his reply. That is also B9 exhibited. After holding workmen guilty, etc., for scrutiny of the court, so as to prima facie ensure that domestic inquiry was held fairly and impartially by observing all necessary procedures. Now, next paragraph, kindly see what the tribunal court done. Since the management has withheld the details of all the above relating documents domestic inquiry, as such, the adverse presumption under Section 144 Evidence Act may be drawn against the management. That is what it has done. But there is a judgment of the Supreme Court, my lord. Suppose their documents are not produced. Even then also, labor court could have taken that issue. They cannot draw presumption straight away like this, my lord. This judgment, my lord. I can give this judgment, my lord. This is the one. Right. Paragraph 12.
Yes.
My lord, I'm just showing you. Paragraph 14. Paragraph 14. My lord, 1 minute. There are in between paragraphs are also paragraphs. Paragraph. Relevant part I'll just show.
Yes, you come to paragraph 14 only. This is what I have been saying. This court has held in a cadena of decisions.
Yes.
Read that.
Yes.
Paragraph 14.
This court has in a cadena of decisions held that where an employer has failed to make an inquiry before dismissal or discharge of a workman, is open for him to justify the action before the labor court by leading evidence before it. The entire matter would be open before the tribunal, which would have the jurisdiction to satisfy itself on the evidence adduced by the parties, whether the dismissal discharge was justified. In four judge bench of this court in workman such held that it is now well settled by number of decisions of this court that where an employer has failed to make an inquiry before dismissing or discharging workmen, it is open to him to justify the action before the tribunal by leading all relevant evidence before it. In such a case, the employer would not have the benefit which he had in cases where domestic inquiries have been held. The entire matter would be open before the tribunal, which will have jurisdiction not only to go to the limited question open to a tribunal where domestic inquiry has been properly held, but also to satisfy itself on the facts it is before it by the employer whether dismissal or discharge was justified. We may in this connection refer to such and such
See,
case.
these are all decisions of what I'm trying to
Yes,
tell
yes,
you.
Cooper, from there it came.
From
Yes.
Cooper only it has originated.
Yes.
Prior to Cooper was Delhi Cloth House.
Yes.
These are all originating right from 70s. In
Yes,
fact, Mr. Nath, prior to the ID Act amendment, there was one case of 68 called Ritz Theatre. Mr. Bora, you can find out Ritz Theatre, RITZ. That was the first decision. In that decision only it was held that in these cases of termination, dismissal before the labor court, the management has all these options. And the tribunal will not just simply, if a matter comes held, whether the dismissal is, the inquiry held by the tribunal is valid, not valid, and end it up. Suppose the tribunal comes to a finding that the disciplinary proceeding held by the management is bad, then the entire matter has to be seen. And while looking into that entire matter, you have a right to adduce evidence, but the only caveat here is that you have to exercise that right.
Initially, that
in the beginning.
Yes.
So generally, you exercise this right when you file your application. Sorry,
WS.
No. There you don't say WS. State written. I think objections. When you file your objections, you specify there that in the event the inquiry is held against me, I may be given an opportunity. And this part is there in Cooper only. In one paragraph towards the end, it is mentioned. Because if you do not exercise that power, then later on you can't.
Cannot take this plea.
You cannot take this plea that I was not given an opportunity of adducing fresh evidence.
Yes, yes.
So I think, Mr. Nutt, ultimately I have to author a judgment.
Yes, yes.
I think it will be better you take out all these decisions and you look into it and then represent your case once
By
again.
this time, I can also learn because
No, most Ritz Theatre, you should start with Ritz Theatre, Delhi Cloth House, Cooper.
Yes.
And then there is one case of 1999, Nita Kalpesh. This
Nita
is Kalpesh.
minor.
This is be 98 or 1999.
Minor will find out. Nita Kalpesh.
So I think till then is okay. And
Yes, it's all right.
everything
Because
will
this is an
come.
opportunity for me also because I have hardly this matter.
So then you have to see how it fits in the context of your case.
Yes.
Because I understand that you never had neither you nor the workmen nor the labor court have framed any preliminary issue.
Taken up this plea.
Correct. I don't think.
I have also checked up, my lord.
No,
Even
I
the
don't
preliminary
think so.
I could not
I
find. I
don't
checked
think
this
so.
issue.
So preliminary issue appears to have not been taken.
Not been.
Now, in the event the preliminary issue is not taken, ultimately the labor court has said that the inquiry proceeding is bad, isn't it?
Yes.
This is what the labor court have said.
And don't presumption.
On presumption, it's not fair.
Yes.
Basically on the validity.
Yes.
So once the labor court comes to a finding that the inquiry is not valid, then the labor court cannot automatically set aside the termination.
My lord.
The labor court ought to have gone into the merit of the
That's what I find in all the judgments. So the labor court cannot say that it is not there. You do it.
But there is a way of doing it.
System.
So you find out all these case laws, you put them together and then connect it to the facts of your case.
Yes.
And the labor court records are here.
I think
They must be here. So why don't you, Mr. Bora, also see what is the stand of the management in your written statements?
Yes.
Whether
copy we have with us.
whether you have taken any plea about the validity of the inquiry proceeding, because sometime I have noticed the management takes it in their written argument, written statements, the plea.
Yes. We have got this copy with us. It is annexed.
Oh, that Nita Kaplesh is 1999 volume 1 SSC 517.
Volume, my lord.
Volume 1.
1 SCC.
517. Nita Kaplesh. In this, they have, Mr. Nutt,
Discuss that.
they have discussed it right from Ritz Theatre. So you will get all the citations, you will get the entire, all the citations here.
I'm so obliged. Not only
It's
for
very
this case.
beautifully, they have, the apex court have referred to all the previous judgments
Yes.
and summed it up in one paragraph, that how to do it.
My lord.
So then you see how that can be fit in the context of your case.
Your case, yes. Then I think that's the best idea, my lord.
That will be appropriate. I think this matter is anyway part-heard before.
Keep
this
it, lord, should be part of it. And so regarding drawing of presumption, just see the
anyway, I'm not going to go on that.
Because that's the second stage.
That presumption.
That's true.
Yes, this is the one. And Ritz Theatre is AR 63, Supreme Court 295. 295. No,
I'm so obliged, my lord. It's given opportunity to me also. Because
no, I just remembered. And you will get.
No, but lordship, remember, in some of the judgments, I found the lordship's name also. This court.
I happen to do a lot of labor court matters.
So I'm concerned. I think this is my second case.
Anyway, so heard Mr. Nath, Learned Senior Counsel, assisted by Mr. D. Bora, Learned Counsel for the petitioners. Also heard MS Kalita, no? A. Kalita, Learned Counsel, appearing for the respondents. Heard in part, we re-post on the. Can we have it on next week? Tuesday?
My lord, not two other matters fixed, my lord.
Next Tuesday? Huh? Not this week, next week.
Yes.
Next week, Tuesday or Thursday?
Tuesday also it will do.
Tuesday?
Thursday, make it Thursday.
Thursday?
Yes.
Next week, Thursday it is. Because otherwise I also forget. I'll forget. You will not need much time. You just go through that 3 or 4 cases and have a look at the case records. because that case record will indicate. Yes.
Now, court motion day. Now, hearing the
Tuesday, Mr. Bora?
Tuesday, I have some
Difficult. Thursday meeting.
18 or 19.
Okay.
19.
I have kept these on record.
Yes,
huh?
yes.
Rupak. এইকেইটা তুমি তেওঁৰ নামটো দি পেলাই থৈ দিয়া। আৰু এই নয়নে দিব দুটা কেছ, তাৰপিছত ইয়াত ভৰাম।
Since I'm appearing, instructions to appear on behalf of respondent of one.
First time.
First time, other council has already left the very bar.
So you want another some
2 weeks
time?
to find
It's one
Wakalat
issue,
number.
Lordship. My plaint was rejected. On
He's appearing for the first time.
Next week,
So
Tuesday.
we'll
Lordship.
give him one chance.
Lordship, next week, Tuesday, if possible, Lordship.
Yes. You can we have it
Lordship.
next week?
Since Lordship, the suit was of the year 2022.
Yes, I understood, Ms. Chaudhary. Yes.
We take 1 week next week. Next Thursday.
Tuesday, Lordship.
Heard M.S.R. Chaudhary, Learned Counsel, appearing for the appellant. Also heard Mr.
P. Kotoki.
P. Kotoki, Learned Counsel, appearing for the
Respondent number 1.
respondent number 1. And Mr. R. Chakraborty, Learned Counsel, appearing for respondent number 2, 3, and 8. What about the other respondents? No. Mr. Kotoki submits that he has been newly engaged to appear for the respondent number 1. Respondent number 1. And accordingly seeks a short accommodation in the matter. Considering that the matter has been pending for since the year 2023, repost on such and such date. 17th?
17.
17. Tuesday.
Obliged, Lordship.